is present today in the court.
Yes, yes. Where is that?
But the informant not come because
Come forward. Where is that?
informant not come because her paternal uncle is due to Sudhikriya. She is not come. Urgent for 10th.
Actually, that's the reason we asked.
Sudhikriya,
I have no knowledge.
Let it be 10.
Yes, 10th.
as a first case.
10th you come. 10th he would have asked your client whether on 10th he can come. 10th.
Obliged. Item 2.
Pass.
Item 3.
Password.
Item 4.
Password.
Item 5.
5.
My lord.
Yes.
My lord, on behalf of Mr. Roth, may I pray for 2 weeks time, my lord?
2 weeks. 6.
19. Item 6.
Password.
Item 7.
Yes.
May I please, Lordship, this challenge has been filed to quash the entire proceeding, including the external. The matter has been amicably settled between the parties, informant and the petitioner.
It's a matrimonial. What is the offense?
Not 386-506 and other offenses. 386-506 and other offenses of IPC.
Where are the parties?
The parties will come, my lord.
You file joint affidavit?
My lord, no, I have not filed. I will file.
Yes.
Joint affidavit before IO?
Yes.
The same order, huh?
Yes. Yes.
Which police station is this?
This is Bodagada.
Whatever.
What is the offense? You are
Bhavani Sankar Paikra and others.
and Amiya Kumar Mahanti.
Yes.
We'll issue notice to Amiya Kumar Mahanti, let him come.
My lord, the question is, it's a problem. You know. There are total 5 accused persons. Now 2 have come up before your lordship.
We will quash these 2.
These 2.
Only obviously. If they are interested to suffer prosecution, let them.
Your lordship.
We can't quash the unless they come to the court.
Yes.
Entire FIR can't be quashed. Why the 2 only? Why the other people have not come? It is settled through them, these people only. The other people have not settled.
Suppose the complainant will say, I settled the dispute between this accused only person number 1 and 2, and I don't want to settle with others. Then what would be the consequences?
Yes, that's a very difficult.
That will create a problem.
In that case, I will take instruction.
We are issuing notice. Issued notice to opposite party number 2.
Yes.
Waive. He is appearing. Respondent number 1. Waive the notice. 2 weeks. 2 weeks. 2 weeks thereafter. Yes. 19. File the requisite and issue note. We have issue note.
Item 8.
May I
Yes.
I have challenged the inter-criminal proceeding on the ground that, my lord, your lordship, FIR was lodged under section 470, 376 2I, 344, 313, and 506.
Yes.
Subsequently, charge sheet submitted,
Hmm.
and cognizance was also taken on court below. If your lordship go through the FIR 164 and 161 statement notes, both are major and both are working as government servants. There is a relationship between them since 2013, and they have resided at different places with the consent of the.
Where is the charge sheet?
Charge sheet is not 11 page 26.
No, you have to file the charge sheet.
I have filed it.
Where is that? Where is the allegation? Let us see.
26, my lord.
26. Okay. Let us see. Read it out.
That one, Ramamani Hembram, my lord. daughter of such and such, Mayurbhanj writing, effect that she had love affairs with Sibo Sankar Mishra, the present petitioner, my lord. And in 2013, for the first time, he kept physical relationship forcibly. In 2014, he called her to his quarter to Baliguda, citing his illness, and she resided there for 5 days. At that time, also he kept physical relation forcibly. On 11/1/2015, he asked her to Hotel Swagat at Baripada, and on 12/1/2000, he put Vermilion and married. In many times, he asked to Hotel Swagat and Hotel Alkapuri and Baliguda quarter. He kept her at Baliguda quarter from 25/16 to 13/5/16 by locking the door. Again, she resided from 4/8/2016 to 23/11 in the quarter. In this manner, she conceived twice and aborted against her will. When she was resided for a long period, he prepared medical fitness document for her. He threatening her to dire consequences and rape. Hence, she reported at PS for legal action. On this, IIC Baliguda treated the written report FIR, register PS case number such and such under section 417, 376, 2N, 344, 313, 506, 467, 416, and requested to Tirupalli Chowdhury, IIC, Kenwaga PS to take up investigation of the case. On his transfer, I took the investigation case. During the course of investigation, the then I examined the complainant, other witness, and recorded a statement under section 161 CRPC. Visited the spot and prepared the clear spot, sent the victim to Baliguda for medical exam, seized the wearing appearance of the victim, arrested the accused Sibo Sankar Halda, and sent for a medical examination to SDS Baliguda, seized the wearing appearance of the biological sample.
Where is 164?
My lord, 164 is there at page 29. Man.
Yes.
May I read?
मोर कोर्ट रे जमानबंदी जे 2010 मसिया शिव शंकर गलड़ा जे कि एसआई पुलिस बालीगुड़ा अच्छी मते फोन करते बारंबार फोन कर फोन सिम नंबर बोधे बदल मु चेंज कर एयरटेल सिम नंबर सच एंड सच पर पुणी उक्त नंबर फोन कर आरंभ कले बारंबार एडा जाते शिव शंकर आला मते फोन करते एपरिक मते पुलिस को जणाइबे मते कहितली एई समय मु शिव शंकर देखि नथली से फोन ने मते बारंबार तांको सहित बाहाबा कथा कहउतली बारंबार व्यवहार परिस्थिति मुझे सहित फोन जोगे संपर्क बढ़ला 2012 मु शिव शंकर अल्लाह को मो सहित देखा करने कहली यही समय से पुलिस चाकरी ट्रेनिंग रे थिले हठात एक दिन बसरे मोर अंगनवाड़ी सेंटर में मते देखा कले अल्प समय कथबार्ता करे अन्य परवर्ती दिन भुवनेश्वर फेरले भुवनेश्वर जावा पूर्व बारिपदर देखा करी पर फोन मध्यम फोन ने कथबार्ता होती मोर आखिरे समस्या मझे मझे आखि विषय कहती से रंगमटेर आई हस्पिटाल कही एक दिन 2013 मसीह रंगमटिया हस्पिटाल को नहीं घर को फेरिया समय आम ग्राम पाखे जंगल में मत मोटरसाइकेल छिड़ा कले कथा बहाना कथा उक्त जंगल मो सहित जबरदस्त संपर्क रखिले यार इवनिंग समय अटे मु मना करने सहित आम दुहे तो बाहाबा कही मोर सहित जोर जबरदस्त शारीरिक संपर्क रखिले बीएसएनएल सिम रखिली अधिक समय पर्यंत कथा उक्त बीएसएनएल सिम रे हला नंबर सच एंड सच गत 2014 मसीह शिव शंकर बालीगुड़ा कटर पाइले से एसआई पुलिस पोस्ट रे थिले गत 2024 मार्च मासरे शिव शंकर देह खराब होला से बालीगुड़ा हॉस्पिटल रे होइथिया समय रे फोन ने मते बालीगुड़ा आसिया पे अनुरोध करे तांको अनुरोध रे बालीगुड़ा आसी तांको क्वार्टर को आस्थिली क्वार्टर रे होइथिया समय रे मते से मो सहित शारीरिक संपर्क रखिथिले मझिरे मते बालीगुड़ा क्वार्टर को डाकुथिले मु आसिले मोर सहित शारीरिक संपर्क रखुथिले घर को छुट्टी जिया समय रे बारीपदा थिबा
she has narrated everything.
yes my lord
Then
it is a consent by
how the consent would be elucidated in the trial?
no my lord
He says without consent in 164 statement.
yes my lord if you
Then I have to presume that despite
No,
her
no,
164 statement, what
No,
you say is accordingly.
no, I am not saying that you will assume a pigeon. My from the conduct from 2010 my kindly my lord.
See, there are charges of 376,
Yes, my lord.
and she says I had no consent. That is enough to face the trial.
And your lordship also know, my lord, Promote Suryavin's power by state of Maharashtra, my lord. When this honorable court and this is the apex court decision, my lord. Apex court stated that when two persons major consented for a long time and have a relationship from 2010 to 2017, it not amounts to rape.
There is 164, I can't help.
My lord, your lordship can't have gone to this judgment, my lord. It is squarely covered, man.
Maybe,
he has-
maybe after the trial, this judgment.
No, it is not after trial, man. It is.
You tell me, do you want an expeditious trial?
No, my lord, your lordship can't have gone to.
I know the judgment.
Yes, your lordship, no. But basing on this judgment, my lord,
Facts are different, sir. See, it is not an isolated incident.
It is equal, my lord, it is totally equal.
That's
to
right.
my
I'll take care of that judgment also. But you tell me, you need an expeditious trial.
No, experience, my lord.
That is the only thing. Yeah, I think you can get it from here. 164 is there in the face of 164. I can't scuttle the trial. Like
Here also 164, my lord.
that's right.
Here in this case, my lord, both
There are many
better.
other. There you keep on reading. There are many other allegations. You can't just.
In this allegation, mother, there is no allegation. I mean, it is under section SC and SC Act, my lord. But that, despite that, my lord, the Honorable Supreme Court passed the proceeding. My lord. Your lordship, and this Honorable Court following this judgment, my lord, our High Court also, my lord, passed proceeding, my lord. I will show this one, my lord. Since 2010 to
So the best could be done is you have persuaded me to issue notice to the informant.
Man.
I'll issue notice to
Yes, ma'am. Your lordship.
same state waiving and opposite party number 2 notice. 2 weeks. We will have to hear. If you are insisting in that judgment,
Man.
and that judgment, there are many other judgments also, but 164,
Well, I will also
see the consistency in the
Consistency,
164.
my lord, your lordship is right, my lord. But my humble submission, my lord, since 2010, till 2017, he has kept relationship. He has married. He has resided in both in the quarter, in the hotel. So for the last 7 years, it amounts to consent.
But subject to correction of my friend, that this is perhaps the third application. before
Third
us.
application?
Yes.
Third,
Yes. And this is no certificate has been given.
where is
Then
that?
I will, my lord, withdraw, my lord. I have no instruction. I am withdrawing, my lord.
Where is that? Where from you got that?
My lord, your lordship may kindly see CRLMC 1327 of 2017 and
See,
CRLMC.
don't do all these things.
No,
There
my
are-
lord, I am
57 of
withdrawing, my lord. My lord, I have no knowledge. I am withdrawing.
No, you verify whether it is
No, yes,
passing or
If my lord and fail, it is right, my lord, I am withdrawing. It is not fair, my lord, without verifying.
See, I go by face value. I don't see all this.
No, no, without verifying, I have
It's
filed.
not fair for you, me, as well as him.
No, no, my lord, without verifying, I have filed this paper. That is my
Now,
mistake.
these clients, they
My
don't
lord.
disclose and thereafter unnecessary.
I am, my lord, withdrawing.
Look, withdraw. Many times this happens. The client
My lord,
never
my lord,
informed.
I have
It's
not-
very dangerous.
I have not.
Yes. Okay.
Before filing, I have to check.
Yes.
I have not checked.
All right.
My lord, I am in virtual mode. I may be pardoned for this.
Yes,
Madam.
sir.
Madam. Sir, this case, I think notice was issued and the opposite party with a file an objection or anything. There are the 2 points of law, my lord, involved in this particular cognizance order is challenged. One is the petitioner filed an FIR and that FIR was registered and a charge sheet was submitted in the year 2021. 22 January. Suddenly, after 6-7 months, one 1CC was filed alleging the same as the same for protest petition, narrating more stories to the whole case, contrary to the FIR story. So the court has taken cognizance in different sections. That is one issue. Second, but my lord, the point of law, that whether the charge sheet submitted and cognizance taken by the magistrate under 190 of the CRPC, can there be a second cognizance by the same magistrate under 20? These are the 2 questions. And it is backed by 2 Supreme Court judgments. The first one is, one cannot develop a FIR story.
1 minute, sir. Are you
Right.
ready? We can proceed.
Yes, my lord.
Right. The first story was cases of Krishnalal Chawla, others, versus state of Uttar Pradesh. There, my lord, my clerk is there, he'll just supply the.
Do you have a junior with you here?
Yes, ma'am. He is just in the other court. I'm sorry for my clerk being supplying. I'm sorry.
Somebody is assisting you, yes. Yes,
My lord.
which
The
para?
first case, the first judgment, the Kishanlal Chawla and others.
Yes,
Lordship, turn to the second page.
second piece, okay.
Right. Being aggrieved with charge sheet filed against him, the respondent instituted a fresh private petition on 11/5/2008.
Where are you reading, sir?
My lord, the judgment, Kishanlal Chawla and others.
Yes, yes, which
Yes.
paragraph you are reading?
Page 436, next page. First paragraph.
First para, okay.
Being aggrieved with the charge sheet filed against him, the respondent instituted a fresh private complaint.
1 minute, I am not able to locate.
Sorry, man.
Who agreed by?
This is Krishna Lal Chawla.
Chawla,
Krishna,
Yes, which paragraph?
I am also not able to listen.
Which paragraph? Krishna
second
Chawla.
page, my lord. Page 436. Page 4. It starts with 435.
No, we have a different print altogether.
You've got lines.
My lord, I'm
There is
sorry.
no page.
Print is different. This is the print is from I think the
Can I have it, my lord, tomorrow?
judgment. It is.
I'm sorry, but because that is important part. Can I have it tomorrow, ma'am?
This is neutral citation.
Neutral citation.
Huh.
Neutral citation. Are they
Which
relying?
paragraph? You just tell me the paragraph. We can look at.
Paragraph, the placenta part, second page, man. Placenta.
No, then it's
Difficult.
You have to refer to paragraph.
Second page is page 436.
Now,
436 page is not there, but second page it is there. Second page.
436 is.
Mismatches, he is holding something.
Because the judgment starts with 435.
Real judgment.
Yes.
This is neutral citation.
I may be pardoned. Can I have it tomorrow? Because I'll come with the right.
That's better, sir. That is better.
Better. Because let me place another judgment. Perhaps if you can take a note of these two judgments. The very latest one.
Can you just give the citation of this Chawla?
Chawla, ma'am. Yes, ma'am.
Yeah.
This is Supreme Court SEC 5 2021, page 435.
435.
5.
Okay.
435.
Other one?
Other one, my lord, this criminal appeal 3484.
You don't
I'll
have
be filing the copy. I don't think it has been taken to the publication. It is
What is the
recent
proposition, by the way? Both the judgment, what is the proposition?
First judgment proposition is that once the FIR is lodged and on that basis a charge sheet is submitted, any protest petition shall be confined to the contents of the FIR.
That's the general principle.
That generally. But
Yes.
in case somebody adds some new facts and files a complaint case enhancing the story to some other facts, then it should not be entertained by the minister. That is one part. So, for the Chawla case is done. Then second part, my lord, Justice Oka's judgment, Ramakant Singh,
Yes.
others and versus State of Jharkhand. Their lordship, the Honorable Court said that once a cognizance is taken under 190 of the CRPC on the basis of the charge sheet, the magistrate is incompetent to take cognizance in 204 because there is no provision of review in the criminal procedure. So the
But
magistrate
here I
was
think
taken.
First cognizance was taken against the one accused, and insofar as the other two accused concerned, the second time the cognizance was taken.
Yes.
The protest petition is qua the other two accused person against whom the cognizance was not taken.
Not taken. That is one part. That is one part.
I just
And that case, my lord, the petitioners have already gone on bail in that case. The second case, where the cognizance not taken against the father and mother, the story has been elaborated in a complaint set, contrary to the affair story. So whether those facts can be taken into consideration by the magistrate when conducting 202 inquiry and taking cognizance in 20. These are the 2 points of law I will be satisfied. Can it be any free day, lordship, or tomorrow?
So the proposition which you are propounding today is once there is a cognizance is taken, qua one accused, qua the other accused, if protest petition is filed, in the protest petition, you can't have aggravated allegation. Contrary to the allegation made in the original,
FIR.
this is what you are.
That's all.
What do you have any supporting judgment?
But right now, I'm not
It-
carrying any judgment, but the facts of the case is that like this, my lord. An FIR was registered pursuant to a complaint petition. Subsequently, it ended up with a charge sheet wherein only the husband was charge sheeted, and so far as the mother-in-law, father-in-law, and
Final
sister-in-law is
report
concerned, my lord, they were exonerated. My lord, the investigating officer failed to examine the informant, my lord. And as per the FIR itself, my lord, if their reading of the contents of the FIR would disclose that each and every accused person was implicated, my lord.
No,
There
in the whether in the protest petition you have added allegation.
My lord, there is nothing,
Yes.
my lord. The judgment which my learned senior is also relying on, but I'll distinguish those judgments. It's not applicable over here. And thereafter, can I be denied a right to file a protest petition, my
No,
lord?
you can fight. There is no doubt
No,
about it.
I
You
don't, I
can
don't
file.
say that.
So therefore,
I
my
don't-
lord,
There is no quarrel on that.
and
Whether you have aggravated the allegations.
there is no question because my lord, an FIR cannot be exhaustive. My lord. It's not an encyclopedia that it should contain all the allegations.
They're the point.
So
They're
far as,
the
so
point.
far as, so I'll come out with those judgments, my lord. But so far as the complaint petition is concerned, it's a verbatim of the FIR. And there were certain, because your lordship would appreciate the fact that whenever an FIR is registered, when a complainant goes to the police station to register an FIR, with my personal experience, I'll say on each and every occasion, my lord, they say that you make it short.
That's
Don't make
right.
it
But
elaborate.
here
So
is a
therefore, my
case.
lord, so-
Here is a case. Investigation has already completed.
Yes, ma'am.
Charge sheet was laid down,
Yes, ma'am.
and the fire was tested
Yes,
on
ma'am.
the investigation.
yes.
Charge sheet is laid down. Against one accused, charge sheet was filed. Insofar as the other accused are concerned, a final report was submitted.
Yes, ma'am.
Qua that those two accused against which final report was submitted, you file
A protest petition.
protest petition.
Yes, ma'am.
The question is whether in the protest petition you have aggravated, added further allegation and all or not.
But there are, my lord, I have
Whether it
all-
is permissible under law.
Yes, my lord. I'll satisfy your lordship on this point. My lord,
Tomorrow,
yes,
tomorrow, day after.
because yes, my lord.
When,
Tomorrow, my lord.
Sir, when can you come, sir?
My lord, either it be tomorrow or on Tuesday, my lord, 9th?
Tuesday.
9th.
Tuesday.
My lord, that interim order, that the extension.
There is no interest.
I'll file the correct copy, my lord. I'm sorry for not having that.
Yes, it's all right. No problem. You can. There is interim order.
There is no interim order, my lord. Only
So
There
there
is
is
no
no
interim
interim order, but the direction was that in the event the date comes with the trial court, we can file a
Only-
petition together.
Only Tuesday. No problem.
Item 10.
May. I have challenged the order dated. Passed on 2/6/2023, Annexure 1, page 7.
Annexure 1, page.
Page 7. The petitioner's motorcycle was seized, my lord, by the police in connection with the,
This you are filing for passing.
no, not passing.
What
Con-
is Bank guarantee 38,000.
Bank guarantee. My lord, the petitioner's is a
What? Which vehicle is this?
motorcycle, Honda motorcycle.
Honda motorcycle.
Amounts to 38,000. My lord, I am prepared to give the indemnity bond, my lord. But along with the bank guarantee,
Which model?
my lord, the valuation market price of the 38,000.
Anything?
This application, I think, my lord, subject to correction, 439 1B.
439.
Modification of the condition.
Modified in the bail application. My lord,
Not
friend,
bail,
maybe
superdari.
what my friend is saying, 439 2 is.
That is the bail condition.
That is bail condition.
It's
is a
not bail.
condition for
It is
vehicle.
the release of vehicle.
Right.
Release of vehicle. You just see whether revision lies against this order.
No, madam. No revision. It is only your inherent power under section 482, your lordship can pass the question. No, exempt the
What was the offense?
302, madam.
You are accused.
Yes, ma'am. I am an accused. The vehicle was released.
You are in custody.
No, no, I am already released.
And this is the final order. This is the final order.
This is the final order.
So against final order, revision lies.
482 also lies.
482 also. Is there any bar?
No, bar is not there, but practice is for revision.
No, no.
The simple principle is a final order where appeal is not provided, revision lies.
Lies, yes.
Simple.
Yes,
Funda.
simple.
Can it bar 482 is barred?
No,
No, there
no
is
bar. There is no bar.
Why to go technicality of tell me what to do?
Condition
Small
modification.
matter unnecessary.
Condition modification will also be
What?
disposed.
Indemnity bond?
Yes.
He has directed indemnity bond.
What is
Along with bank guarantee.
indemnity motorcycle let it be indemnity
Yes.
bond.
Tako.
Where is that order?
My lord, page, in relevant page 10, my lord.
What is the stage of the trial?
Trial is going on.
No, trial will definitely go on, but what is the stage?
My lord, charge sheet submitted.
Case of 2019.
19.
Right.
Case of 2019.
It is not yet released vehicle.
No, the order was passed in 2/6/2023.
Operating part just.
My lord, operating part, my lord, your lordship, page 10, my lord.
10.
Paragraph 1, my lord.
Page 10. Yes. Paragraph
last line, my lord. Of paragraph I.
Tell me.
My lord, the petitioner is
Petitioner
to file an indemnity bond to the tune of the valuation of the vehicle fixed as per the report of the Inspector of Motor Vehicle, Nayagarh, Supra, along with the property surety and bank guarantee to that extent.
Property, security, bank guarantee, indemnity bond, everything.
Sub condition.
ठीक है.
गाड़ी नष्ट है.
The petitioner.
It's a confusion.
Petitioner has filed this 482. Petitioner is invoked the jurisdiction of this court as of under section 482 CRPC, assailing the order dated 2/6/2023, whereby the learned trial court, while releasing the offending vehicle.
My lord, the vehicle was used for the crime.
Releasing the motorcycle, which is being used for commission of the offense, imposed the following conditions. Page 10, page 10, page 10 I. So, therefore, the petitioner is aggrieved and seeks indulgence of this court. Heard the learned counsel for the state who Mr. Sonto, heard Mr. Sonto, counsel for the state, who has vehemently opposed the prayer made by the petitioner. Having heard the parties and gone through the record, this court is of the opinion that the vehicle, what is the number of this vehicle? The motorcycle, bearing number so
OD 02AU 2306.
Oh, Honda motor. What is that motor?
My lord, Honda Unicorn motorcycle.
Honda motorcycle.
Page 11 description is there. Last part.
Shall be released to the petitioner on Superdari, invited command Superdari, with a condition that he should file an indemnity bond to the tune of the valuation of the vehicle fixed as per the report of the inspector of motor vehicle. That is 38,000.
38.
That is 38,000. Next paragraph. The impugn orders dated 2/6/2023 stands modified to that extent. Disposed of. Yes. ए आपण एथिरे आगुर फाइन करनांदी
ବ୍ୟାଲଟ ଏଇଟା ଅର୍ଡରଟା ହେଇଛି 23/6 ରେ ତାପରେ ସାଙ୍ଗେ
हां
May please, Your Lordship.
yes
Lordship, the petitioner is challenging under section 227, petition has been rejected by the London trial court on the ground that Your Lordship kindly turn to page 149 under annexure page 10.
page 10
No, page 149.
yes yes
So, next page is Your Lordship.
how many of you are there here in this
Sorry,
how many petitioners are here
only one petition.
what is his name Vikram Mishra
Yes,
Okay.
the present petitioner is working as a ARS, Assistant Revenue Inspector.
Hmm.
Still he is continuing.
you are accused number 4
Yes,
tell me
so the present petitioner is not involved in this case. Only he has done his duty as per the direction by the his authority, Lord. Because he was working, the present petitioner at the time of he was working as a chairman. So allegation is that, Your Lordship, the informant plot has been muted in another name. But the allegation is that the present petitioner has not served the notice, Your Lordship. It's because I'm pointing out, Your Lordship, we cannot pay the Your Lordship. Page 154.
was read the MP note 150
154 under annexure 11.
yes 154 right
Yes.
read
Though the present petitioner was already served to the informant at the time of mutation.
which annexure
Annexure 11,
11
page 154.
what is this
Next page, Your Lordship, that is relevant to page 155.
you complete one annexure thereafter you are coming to 10 sometime let me complete let me understand what is document this document is not visible at all
No, I have taken the certified copy of the.
what is this document
This document is the informant alleged that, Your Lordship, the present petitioner was not served the notice at the time of.
you
mutation.
say that you have served the notice
Yeah.
that is a very good defense for you
Yes, Your Lordship.
next
Next is, Your Lordship, though as per this honorable direction, order dated, Your Lordship, kindly say
what are the offenses
offense, Your Lordship, that is 420, 468 and 471 and 3405.
and you tell me who all are these accused Ramesh Chandra Barik
Ramesh Chandra Parik and next another Dilip Kumar Sutardar.
Huh?
Against that person, the informant alleged though the present petitioner is not in the FIR also, only on the basis of one code.
but these RI chainman and Kanun Go these are the people those who create all problems
But the Tahsildar is the.
you file a 227 petition which was turned down
Yes.
you have challenged that this
Yes.
order
Yes.
you face the trial
Your Lordship, because of Your
No,
Lordship,
no.
the present petitioner.
it's very difficult
Because
case.
of, he was served the notice as per direction by the higher authority.
So everything
And
is
then-
being done by higher authority only.
Yes.
What kind of your higher authorities are I?
Yes.
And you are the person who is in the field and you create all the problems.
Your Lordship,
See this-
Your Lordship, for a moment.
And you also know that RI and this chainman Kanun Go what they do,
No, Your Lordship, only the.
particularly in this
For
area.
a moment, Your Lordship, kindly consider. Only on the basis of the affair, the allegation is that, Your Lordship, the present petitioner was not served the notice. Because.
Charge sheet, show me charge sheet.
Yes, Your Lordship.
Where is the charge sheet?
That is, Your Lordship, under annexure 2, page 90. And that has been only preliminary charge sheet has been filed on 5/2/2017.
Only preliminary charge sheet.
Only
Final
preliminary charge.
173.8 is open.
Yes, still open.
So now how you have asked for a discharge, 227, how it is maintainable?
Your lordship, earlier approach before this honorable court.
Investigation, something else may also come out. Who knows?
Your lordship. for a
Very
moment,
charge sheet, very charge sheet.
That is page 19.
19,
Yes, sir.
19.
19.
It ends at a page.
Page 19.
Many materials are there. Many materials.
Only one co-accused named your lordship, that is
No, no.
Rustom Koa.
Where is 165? Huh? Charge has been framed.
No, illegal, no.
Discharge application was premature. No, I'm not going to quash. What do you want? Will you withdraw or shall I make?
May I pray your lordship kindly issue notice to your lordship?
No.
Yeah,
Very, where no question
the
about in this kind of matter. If I'll start interfering, then there is no end to it.
Then for a moment, your lordship kindly.
So what I'll do is the best thing is I'll keep all these arguments. You keep it open for the purpose of arguing at the stage of charge.
I'll say just one thing, your lordship kindly consider your lordship.
Yes, sir.
Before earlier the petitioner approached before the honorable court. Your lordship, this honorable court has directed to file the discharge petition before the trial court. So accordingly, the petition was filed before the trial court, your lordship.
And it is now rejected.
But your lordship, what happened? Your lordship, they have not considered.
Not required. Just see. There are evidences and evidences here. 161, what not, everything. And if you start reading, your role is apparent.
May I permit your lordship kindly for a moment turn to page 125.
125. Okay.
Yes, sir.
125.
Yes.
What is that?
That is this honorable court's order, your lordship.
I know that. I read it.
Yes.
First, I read that only.
So the present petitioner name is not in FIR.
That's not necessary.
I have relied some judgment also, your lordship.
See, facts.
Next.
Facts. See, you have to clear the facts only first.
Only my prayer before your lordship, only the allegation is there. The present petitioner was not served the notice to the informant. Only that allegation.
That may be.
I have taken a certified copy of your lordship and permit to guide.
Maybe. See, you might have prepared this notice and kept yourself. How do you know? How do you know? It is a matter of trial. Matter of trial.
We pray your lordship kindly, the present petitioner, so the.
This notice, give me the proof. Show me any document which indicates that you have really served.
Yes.
Where? Yes, means show me.
I have annexed you.
His signature. Show his signature in the notice.
Yes.
Has he received?
Yes.
Show me.
Also
where is that?
Certified copy for me.
Has he signed?
Yes. Signed. Kiran Kumar Mishra.
Which notice is this?
That is the mutation notice, your lordship. And he has written also, may I read for me to read, your lordship.
Hey, what is the date? What is the date?
That is the 7/5/2012. 7/5/2012. ପ୍ରାପ୍ତକାରୀଙ୍କୁ ଏକ କଥା ନୋଟିସ ଜାରି କରି ଜଣାଇବି ତଳେ ସେ ବିକ୍ରମ ମିଶ୍ର ସାଇନ କରିଛନ୍ତି 7/5/2012 ଉପରେ ସେ କିରଣ କୁମାର ମିଶ୍ର ସାଇନ କରିଛନ୍ତି।
How the impugn order, how the impugn order deals with this? Let me see.
Your lordship may kindly turn to page 152 for a second, last 5 line.
Yes.
Last 5 line I am reading now.
52.
Yes.
Okay.
152.
Yes.
Second para, last 5 line. I am reading that.
Read it. read the full paragraph further.
Yes,
From
yes.
the
Ma'am.
statement of
Further from the statement of the witness, namely Subhash Chandra Rai
Hmm.
and Pitamar Jena, as well as the accused Vikram Mishra, recorded under section 161 of CRPC, it reveals that there is involvement of the accused Vikram Mishra in this case. So also from the statement of the accused person, namely Pitambar Jena and Vikram Mishra, recorded under section 161 of CRPC, it reveals that they had issued notice to the house of the informant Kiran Mishra and one Ramesh Barik, but in mutation case number 281/12 and 282/12 for the greed of monetary benefits from the accused person named Chakradhara Nanda and Ramesh Barik, they had not sent notice to the real landlord of the property. Instead of Kiran Mishra, the accused Chakradhara Nanda and had signed on the notice, and they had also not verified the power of attorney properly, for which the said plots are muted in the name of the other parties. Further, it also reveals the IO, after completion of the investigation, submitted charge sheet under section 420, 468, 471, 120B, 34 of IPC against the present accused, along with the other associate in the alleged crime, and there is prima facie materials to proceed against the present accused, along with other accused for above noted offences. Under the above discussions, the petition filed on behalf of the accused person almost regard to the order of Hon'Ble High Court, the petition to discharge the accused namely Vikram Mishra for the charge under section 420, 468, 471 and 120B, 34 IPC is rejected.
No.
But
no.
this is purely everything has been described by the.
You want a order, or which may prejudice you in trial? You think over it. That's fair. That's the fairest thing one can do. Okay.
Disposal.
Disposal. That I'll see, because it is a very initial stage. You are on bail. No, you are on bail.
Yes. If I was lost since 2015 years.
15.
16.
Charge sheet filed.
Charge sheet filed. Only preliminary charge sheet has been filed on 17.
That's right, but you are delaying it. You are coming to High Court, taking liberty, going filing 227.
There is no final charge sheet till yet has been filed in what? The trial court that has been filed, but
where I couldn't see where they've said that 173 is 8 is open. Where is that?
Say paper ta annexer karna.
Where is that part?
That is your lordship written in lordship page
19.
They have written preliminary.
That may be, but
the last page of the charge sheet has not been
written.
Last page ta apon deina di. Last page charge sheet.
Dekhontu 173 clause 8. पुलिस फॉर्मेट रहता है उठे ही फाइल कर देना. तार अर्थ ज्ञान नहीं पड़ते. Where is that?
अरे सैडो खोजले कोड पाइबो ना जे सेंटर बही ताकू कोड दियो. चार्ज शीट और लास्ट पेज अपन देना तो खोजले पाइबे. पोस्टेज ऑफ टाइम. सीधा कथा को.
See, if you say it is a preliminary charge sheet, 173 8 is kept open, then your 227 application was not maintained. If there is no final charge sheet, you want a discharge. How do you know in the further charge sheet some other evidence may come? How can the trial court preempt everything and pass the entire charge sheet, preliminary charge sheet, before the final charge sheet comes? So this argument goes against you. Better that you keep it quiet and get in order for expediency.
After 1 year, after 1.5 years, they filed the preliminary charge sheet. And now the 2024.
It may be a scam also. It's not a case of isolated land. You might have created a lot of problem for others. So that may be the reason they have kept it 173 8 open. That may be a reason. Any other complainant will come, then they will start. It may be a racket, who knows?
But in this case, the Tahsildar is not active.
That is there,
Because of he is the authority to issue the ROR.
many things happens. Better not to say it. Chalo, I'll do it.
Yes.
Okay,
I'll do
next.
Item 12.
My lord,
Yes.
against the 311 petition was rejected by the Law and Court below. The petition has filed this court to application below. Last occasion, Lordship, the Honorable Court directed to file the 311 petition below. Lordship, may keep it tomorrow so that I give the copy to the state also. I will file
Tomorrow.
Oblig.
Give a copy so that
I will
tomorrow.
I've got one copy.
Tomorrow. Tomorrow day after. No, Monday. Monday. Yeah. Yes, yes.
Item 13.
My lord, I'm for the OP number 2. My lord, Mr. Mishra, my senior L. Mishra, he's on accommodation today, my lord.
Then you should
My
grab
lord,
the
we have
opportunity
to-
and argue.
My lord, we have to file the counter 2 weeks time. We wanted to file the counter.
This is the best opportunity for you to argue.
My lord, we have to file the counter. The counter is.
What is the case, by
necessary.
the way? Counter may not be required.
My lord,
What is the case? You tell me first.
my lord, it's a 420 case, my lord.
What are you asking in this petition?
My lord, the
I am for
petition.
the petition.
Yes, my lord. We are for the opposite party number 2. We are the complainant, my lord.
Counter is required.
Yes, my lord.
Why?
Counter is next.
Why counter is required?
Yes, we are the informant. We have to.
You might not have read the petition at all. It seems.
On 15 to 2023.
1 week?
2 weeks time, my
2
lord.
weeks.
But there's an interim arrangement. Let me continue.
Interim order is there.
Yes, madam. By order taken to Lordship was first part on 2/2/2023. Then on 15 to.
Interim order passed earlier, sir, continue. 19 will do.
19th, yes, ma'am.
Next time when you come, you read and come.
Yes, ma'am. Obliged.
Interim order earlier passed, shall continue till the next date of hearing. Next.
Item 14.
Yes.
May it please your answer.
Yes, sir.
This has been listed for further orders with regards to stay. If my lord will hear it, when on merit, it can have no. Because the interim order was granted on 16 to 2023.
16 to
2023. State Council was directed to bring the case diary. They have further proceedings in this further.
it's stay order.
Case that is there, my lord. But in fact, my lord, my lord as senior challenge order 15/11/2022, my lord. They the petitioner filed a 227 petition for discharge, my lord. That are rejected, my lord. The case, my lord, posted to
Right.
17/11/22 for
Right.
family charge, my lord.
No charge.
That 7/22 for that is in my lord. Whether charge has been framed not, my lord.
Charge has been framed or not?
For that is I am, my lord.
You are depending upon him.
My lord.
You are supposed to get.
No, but that order has not been, my lord, given, my lord. And the case diary, my lord, obtained from the IO, my lord. That is with the court,
You
my
are
lord.
the state, you are prosecuting him.
My lord.
You are supposed to know.
My lord. In fact, my lord, that registration has not come, my lord. But in fact, my lord, senior challenge
Then
the order.
let him enjoy this order for some more
My lord.
time. You tell, sir, when you want.
Ballot, first week of, second week of February.
Then, whatever date suits are there.
Entry order to complete.
Sir, there are some defects also you have to cure.
But 14A, have, was not there earlier, 14, I believe.
Let him cure the defect. Whatever defects are there, you cure it and then.
Sir pointed out that it will be revision, not fair elements.
Yes.
My lord, since
That has been entertained already.
no, no. Against charge, my lord, the revision is maintained. So far, my lord senior challenge the order of rejection of the discharge petition. That is the whole problem.
But see, 482 is now entertained.
Man, the moment,
Some orders are passed.
my lord, the moment, my lord, the charge has already been paid, my lord, then this petition is not maintained as because my senior not challenge the order of charge. Must have been, my charge must have been framed, my lord. I'll take it. He also
Against rejection, 227 petition rejected.
my lord, against that order, my lord.
He can maintain 482.
My lord.
If it is against a rejection of 227,
My lord.
482 can be maintained.
My lord, against for maintain, my lord. Since my lord, senior challenging the order of rejection of the 227.
Then,
But in fact, my lord, charge must have been.
This for also my lord should be answer. This I will send.
February 6th.
My lord,
13.
13 February.
Defect may be ignored.
I will not ignore, let it be. We'll see.
But 13-2.
13-2.
Interim order to continue.
Because there are two orders basically. Once the formal charge is framed, against that revision lies.
Yes.
My lord.
But if you move an application, your discharge application is rejected. Once it is rejected, then another order will be passed that is framing up charge.
Yes.
Against that revision.
Yes.
But in 227, 482 lies.
Yes.
So therefore, there is no problem.
Interim order to continue.
Interim order to continue.
Item 15,
Item 15 then pass over one.
Pass over.
item 16.
After lunch. Let it be next week if you are not well.
No, my brother will have to, he's on his leg at.
Okay, after lunch, no problem. We are passing it over in any case, it will come after lunch only.
Hello?
Once we pass it over at 2 o'clock only, we will take it up. Okay. Yes.
Item 17.
17 NIR case the petition is accused and his matter has been settled and all the amount he has received by the opposite party filed affidavit.
Where is the opposite party? Satisfied?
Yeah.
Okay. Where is that memo? Compromise petition.
Compromise petition along with memo. Receipt of amount.
It's compoundable offense.
Yes, NIR.
So why 482? You could have gone to that court and do
After conviction.
After conviction, this appeal.
Yes.
What does he check?
Check amount is 8,50,000. And he has
And where is the conviction order?
order is annexed 1 million.
1. Babu Patra. Proceedings Behra. लिखो जी वकालतनामा you have filed the वकालतनामा write down
After.
huh?
Name is there in the-
Though my lord, nothing to say in this case, my lord, since arising out of complaint case. In fact, my lord, the other provisions are there, my lord, left to them, my lord. They have filed appeal and a revision. My lord.
They've settled why write down the present case is arising out of a dispute under section 138 NI Act. The appellant or where is that? Petitioner. The petitioner faced the trial under section 138 NI Act for not honoring the check number, check bearing number 627042 for an amount of 7,52,000. 7,50,000 issued in favor of the opposite party. Opposite party number? Sole opposite party. Opposite party. Opposite party. After the trial, the learned
Here is the opposite party number 2.
Huh?
That is the opposite party number 1.
opposite party number 2. After trial, the court of subdivisional judicial magistrate Fulwani, by order dated 19 July 2029, has been pleased to convict the petitioner accused. What happened to the appeal? You will not file appeal. Convict the and sentenced the petitioner. Sentence 27. Sentence the petitioner to sentence convicted the petitioner and sentence sentence him to undergo a simple imprisonment for 1 year and also directed the convict to pay 8,50,000 rupees as compensation under section 357(3) of CRPC, and a default sentence of 2 months was also awarded. So after the conviction order passed by the SDJM Fulwani, now the accused has entered into a settlement with the opposite party number 2. The terms of settlement has been placed before this court. Terms of settlement dated
8/10/2022.
8/10/2022 has been placed on record. The opposite party number 2, who was the complainant, in whose favor the check was issued, has been paid the amount by the petitioner to his satisfaction. Therefore, the opposite party number 2, oblique complainant, doesn't wish to proceed with the matter. Accordingly, proceed with the matter and wish to put quietus to the entire dispute. Next paragraph. Therefore, the present petition deserves merit and is accordingly allowed. And कौन क्वास करे पे मांग के लिए अपन कौन क्वास पे मांग अपन एक्चुअली appeal फाइल करके appeal रे करिया कथा 482 फाइल कर चंदी
कति कोई लंबा चलता था since it is compoundable, right? Since it's compoundable,
that's right, but there is
all the amount. I'll memo receipt here.
what while how can I quash the conviction order?
It is
in a 482.
At any stage it can be.
At any stage it can be done, but if there is a conviction, it should have been done by the appellate court.
At any stage it can be crossed.
It can be quashed by whom? After conviction.
After conviction, after
So
conviction.
then appellate court only.
No, after all, also.
How?
For it is
Show me
written on-
judgment.
Yes, I'll show the decision.
You have to file an appeal. Appellate court has to
For that in time.
No. The Honorable Supreme Court has in say certain of cases, it is observed. that
Okay,
NI
forget about Katina. Show me one.
Just one person.
Passport.
Just one person.
Cut a month. Oh, judgment.
I'll
Give one judgment so that at least
For
we
that
can't
in time.
pass wrong orders, na?
No.
My lord.
No.
It has to be quashed.
It-
But the only problem is the conviction is there.
Understood.
You file 482 instead of and I tell you, there is a judgment of Justice Balkrishna. Chief Justice Balkrishna, there is a judgment. I tell you, the judgment says that at what stage 138 petitions can be compromised. And if it is compromised at the trial stage, check amount plus 15%. If the first appellate stage, check amount with 25%. And if it is in Supreme Court and SLP stage, check amount with 30% or something.
And they can file there at the appellate court of the regarding the compromise. The
Damodar S. Prabhu versus Royal Babulal. Honorable Supreme Court handed criminal appeal number 963 of 2010.
ଆପଣ ଦୁଇଟା ରଖୁଛି at 2 o'clock you come with it.
Another case,
2 o'clock. Huh? Which one? Oh, where is that? Is it 480?
it will be better, my lord, if direction obtained from the Sun Court and go there and the appellate court, they can file compromise petition. Settle.
No. It can be settled. It can be settled by any stage.
Who says no? But whether in this proceeding can I do it or not?
Yes,
That's the
exactly.
question.
I'll satisfy you.
Just 2 o'clock, you come with some judgment.
Yes.
Show me. You can't pass wrong orders.
May I please your lordship? My lordship, I am appearing on behalf of Mr. Rajiv Rath.
1 minute, 1 minute.
Sun.
This is again a criminal appeal. That's what I'm saying.
It will be better, my lord, obtain direction from this court and go there and settle the dispute.
I'll write everything and I'll relegate them.
He will acquitted there.
Easily. Next. Yes.
My lordship, I am appearing on behalf of Mr. Rajiv Rath. My learned senior is on accommodation. So this matter
Okay.
kindly
Which
be
one?
taken after
Which one? 18.
item
Urgent.
18. Much obliged, my lords.
No.
Urgent a lot.
Urgent. 19, huh?
May I please, my lord?
19 urgent.
No, 19.
18 urgent. 19 you want. Just
Yeah.
I'll come within 2 minutes. Yes,
May
19.
I please, madam? My lord, this is a case under 498A. My lord, the petitioner number 1 and 2 are the brother and sister-in-law of the accused. That is the husband of the complainant. My lord, if they were named in the FIR, it's a template FIR. But in the charge sheet, they were exonerated. There was nothing in the. But in the trial, their names have once again appeared.
319.
My lord, no.
There's someone under 319.
No. That instruction I don't have, but
If the charge sheet you are exonerated,
my lord, the charge sheet doesn't.
you are not facing the trial then.
But we are in the trial.
How you then there must be 319 summons.
Maybe I don't have that
They
instruction.
have not filed the copy of the charge sheet. Whether say they have charge sheet or not.
Charge sheet,
And 4 witnesses examined in the meantime.
5 witnesses examined. The charge sheet.
How you become accused?
That's what I'm just. That is the reason. The point, my lord, for your lordship's kind consideration is that the petitioner number 1 is an assistant professor in the Centurion University, and petitioner number 2 is a scientist who goes abroad to pursue his academic interest. All the 5 depositions that have been recorded have turned hostile. Whatever may be the case, it may be pursued against the prime accused, that is the husband, and those who are charge sheeted. My simple submission and prayer before your lordship that it may be cast against these 2 petitioners who are nowhere related.
We should know whether they are
accused or not. That is
how have they come?
My lord, may call for the records from the Lord Court and examine this.
Once you call for the record, then it is
Really?
detrimental to your interest only. Trial is going on.
My lord,
and it
that is also very slow process. The 5, according to my
Shall I expedite it?
my lord, that has.
I'll target it.
My lord,
What is the stage? What is the stage?
only 5
witnesses examined.
Huh?
5 witnesses
How
have
many
been
witnesses are there?
out of 20, my lord.
charge sheet they not.
No, that I can give, right. I got it later. So,
Yes, let us.
your lordship, the law.
How you were summoned that, and how we are facing the trial, no, you should know that first.
My lord, within a week, if can called upon the records, can we quickly
No, the
discuss?
record I'll not call unnecessary. It is not in your interest, I
Right.
tell you. Let us try and do something.
Because he's not being able to go abroad because of his visa and other things. He's a bias.
20 जन अछंती 20 witnesses ठीक है कितने एग्जाम नहीं चल लेनी
5 जन agency last was in the month of December 2022, your lordship.
the charge sheet was filed somewhere in 2020
My lord.
Whether they have charge sheet or not, what is?
They have not been charged.
then they are not charge sheeted why you asking for questioning?
They are being summoned. That's what.
How they have summoned
That instruction. Kindly let the matter come next week. I will come with the.
no,
instruction.
we'll target it. You just tell me next week we'll put it, but you must know how have they come. If
My
the charge sheet is not filed,
My lord,
there must be some material which might have come on record in the during trial while examining these witnesses, the 5 witnesses. Therefore, the court might have invoked 319 to summon you, and once it is, you have been summoned under 319, proceeding cannot be quashed. You have to challenge that order of 319.
My lord. But the 5 witnesses that have been recorded have all turned hostile. I have filed.
So if they are hostile, then how you are accused then?
that is the point. That's why I'm taking time.
So therefore,
Next week I'll come.
Therefore, you get
I'll come with the information.
Monday.
Monday.
8, huh?
Monday.
Huh?
9.
9. Tuesday.
My
Get full instructions so that we can.
my lord on 10th because 9th I have.
Okay, 10th. No problem.
Obliged.
But come with full instructions.
My lord.
Item 20. Password. You're 20?
21.
21.
21.
Password. Why today everybody is avoiding password? 22.
22.
Weeks, 2 weeks after. Yes.
23.
May I please?
Yes.
Lords, the petitioner before my lord seeks the indulgence of this honorable court, my lords, thereby challenging the FIR, my lords, dated 23/5/2023, my lords, on the ground that the present petitioner belongs to the scheduled caste community, my lords, and a case under section 31R, 31S, 32VA of the SC/ST POA Act, along with ancillary offences as in 294, 323, and 34 of the Indian Penal Code, was lodged against him. It's the very inception of the section 3, my lords, have quoted it at page 5, my lords. Whoever not being a member of the scheduled caste or a scheduled tribe.
Yes. 5, huh?
My lords.
Yes. Whoever not being, yes.
Not being a member of the scheduled caste or scheduled tribe. Lordships, for a moment may come to page 13, 13, my lords, running page 13, annexure 2, my lords.
Don't read, while reading something, don't read in abstract. You tell what is your proposition and on facts, and thereafter you come to the law. What is the fact?
Fact states that the FIR, my lords, it states that the petitioner, who happens to be the husband of the sitting Sarpanch, my lords.
Sitting Sarpanch?
My lords. While asserted the informant by means of slaps, my lords, and thereafter hurled caste remarks on him.
Right.
On the strength of that, the FIR was lodged.
Sushant Das is the what you call the victim.
My lords.
Okay.
I have read him.
You are Dhananjay Dalai.
My lords.
Right.
He is the OP1, my lords. The informant. And at annexure 2, my lords, page 13, the caste certificate of the present petitioner has been attached, wherein it is clearly stated that he belongs to the scheduled caste community.
You,
my lords, the petitioner.
Then it's all right. Then what is the provisions involved? SC/ST provision goes according to you.
31R, 31S, and 32VA are the
that goes. But what about 294, 323, 34?
That would continue separate.
My lord, the investigation is going on, my lord. And they have
investigation may go on, but what he says is he himself is scheduled tribe.
My lord, he has filed the certificate annexure 2, my lord. I will take instruction regarding, my lord, the general certificate, my lord.
If that has to be verified, but if he himself is a scheduled caste, SC/ST Act will not apply against him.
My lord.
So that part goes, and 294 and 320 will remain. 323 will
only, my lord, I will.
That is again is important. These are the stringent provisions invoked against him, which is
only, my lord, I will take instruction regarding genuineness of the.
Then yes, right. The petitioner invoking the jurisdiction of this court under 482 seeks quashment of the criminal proceeding initiated against him under section page 7 under section so and so ST Prevention of Atrocities Act, blah blah. Okay. He relies upon a caste certificate issued by the competent authority. You are competent authority, with according to which he belongs to scheduled caste community. Therefore, under the provision, therefore, under SC and ST POA Act, POA Act, he could not have been prosecuted, being a member of scheduled caste community, being a member of scheduled caste community. The counsel for the petitioner submits that in so far as the allegation pertaining to the offences under SC/ST POA Act is concerned, uh, the same, same responsibility time to verify the genuinity of the certificate placed at NHS 2. That is adjourned to 17 of January.
Will extra copy. Extra copy.
No, you give.
Mr. Governor, take it.
Next. 24. 24. 25. 25. 25. All the points.
My submission may kindly be related to that because continuing as limited scope. They will not consider these as
What is
because
this order is passed with
no,
this
during
matter?
that during pendency of that I received the notice from individuals forum. That is under the line of the union. That's why I filed these allegations are correct. Then why RCR has been
I'm not able to follow. What is this judgment? What is this order?
this order is to all the in connection with this case. In connection with this case, but during pendency of this process, I prayed for withdrawal, but this order was passed.
Which order was passed?
This that is on 11/5/2020.
Which NHS? Which NHS?
No, not annexed. This order I passed this. He is saying like that prior to this. He has paid withdrawal, but this order was passed. That's been
You ask for withdrawal of this petition.
Yes.
Instead of that, this order is passed.
Yes.
Therefore, you file another petition.
No, during pendency of that criminal mistake, I received a notice from family judge Mohan. That is under section 9 of Hindu marriage. That's why I filed another application before, and that is this application that is 3550.
What do you want?
Person of the entire proceeding because nothing is that is inside the
But
statement.
he said that you won't argue everything there.
Yes, my point to be considered your that observation may kindly be given.
Absolutely, you can argue. I can't review this order.
Certainly, I'll again come now. So that's why I filed this application. Because 239 has a limited scope.
No, you are whatever you are.
Because
This order is already there. You can't. I can't.
they are up to only one annexure.
But there are whatever changes occur, you can't keep on filing in 482 one after another.
But you will have to make kindly. This one is there. FR story, 161 story, and charges both all are done.
All these things are all right, but there is an order now. There is an order.
That
On right,
observation may kindly be considered. You will also may observe that.
what will I do?
These points may be considered and the kind.
Same order has passed.
Same material is 239 limited scope and
But what to do this order? Challenge is go to it. Better.
no, I pray for
Similar order has passed. Same order. Same order.
my statement with that will help me.
Any order which I will pass, varying this one, is tantamount to reviewing this order. Can I do it? Because it is your question. I thought you were writing some modern case.
No.
By booking the jurisdiction of this board under UCR. First point, the charge sheet. In the year is number 938 of 2022. 2020 in the court of SDGM it appears the petitioner had earlier the court, this court, by filing criminal case in Third, the responsible petitioner and counsel on the state. If you the auto pass the petition is also disposed of with the same observation. That is appropriately charge stage, you can file 27, you can file argue on charge. All the cases, there are many cases. Yes. Next step. You are the admin. In the 125 already. What is the relevancy of his medical condition in a maintenance condition? No, the medical condition will not deprive him from, and rather the maintenance should be increased. Okay. There are two distinct issues. Issue is she is a psychiatric patient. She has voluntarily leave your company. If she has voluntarily left you from your company, then she may not be entitled for 125 relief. But in so far as the psychiatric part is concerned, that will not affect the maintenance part. Not. Again, you are linking that to the voluntary. Let us see what is the logic, reasoning. Annexure 1. Yeah, read.
On the other hand, that this case being of year 2021 accordingly provides the 4 of the 125, this case should have been disposed of within 60 days from service of notice on OP. Admittedly, case has sufficiently legal and since the concerned document has already been executed without objection on the side of the petitioner, it is supported by FR that the innocent lady, when ill-treated by the in-laws, is definitely mentally disturbed. This is the finding your worship.
Yes.
Hence, in my view, further lingering matter, the issue of the law is looking. But if he renders this finding, but if prejudices how can we at the time of the say that due to my person he became mentally sick? When the case is that he was a mental patient prior to even marriage. This will prejudice me, my lord, in the final adjudication of 125. He should not have rendered such finding.
No, this finding, how it is hurting you? I don't understand. Exhibited without objection from the.
Objection, it is supported by that innocent lady by your law will definitely be mentally disturbed. But how can you come to finding this one?
What is this concerned document? Medical document?
Medical document, I have showed the prescription, medical.
That you have not objected to it.
No,
just she read it.
No, I have.
Admittedly, this case is sufficiently linger since the concerned document has already been exhibited without any objection. You have not objected.
No, he has not exhibited. I have exhibited the medical certificate. He has not objected to this.
Then it's all right. She is psychiatric patient. It's all right now.
No.
Why should you further want to enhance your evidence? Which observation? I'll expunge this observation.
Yes, you can actually explain that observation.
Which observation? Which part? This is only for the purpose of 125. This will not prejudice you. I'll write it.
Yes, that is.
Which part? You just see. Hence,
Yes, sufficiently linked and since the concerned document has been already executed. This is my law.
Your that is regarding the medical condition. There is no objection. You have exhibited. So further evidence is not required.
Not
right.
From the side of it is supported by the report that the innocent lady when
This part, it is supported by the FIR.
Yes.
That an innocent young lady, when ill-treated in her in-laws' house, will definitely mentally disturb. This is the mentally disturbed. She is saying that because this part is not called. I'll. Write down. Whatever you are asking for quashment of that order. Okay. The present petition is filed under section 482 CRPC, seeking quashing of the order dated 20th July 2023, passed in CMC number 49 of 2021 by the Family Court Bargat. Family Court Bargat. By the said order, the Family Court has rejected the application of the petitioner husband seeking to examine the doctor who is seeking to examine the treating doctor to establish that the respondent wife has been is a patient, is a psychiatric patient, is a psychiatric patient. The perusal of the order indicate that certain documents, certain medical prescription was tendered on evidence by the petitioner, which has been taken on record, taken on record as exhibit without any objection from the respondent wife. Therefore, in my view, further examination of the doctor to establish further examination of the treating doctor is not called for at this stage. Having said that, Mr. Bose pointed out that there are certain observations, particularly the observation inverted comma mein, observation made by the trial court to the effect that inverted comma mein, it is supported by from here. It is supported by the FIR that the innocent young lady, when ill-treated in her in-laws' house, will definitely mentally disturbed. Inverted comma close. The observation so is may prejudice him in the final determination of the final determination of the maintenance. According to me, these observations should not prejudice the petitioner, as the same are made at the interregnum stage. However, without going into the nicety of the observation and the effect of the observation, this court feels appropriate to expunge that part of the observation made by the learned family court in the impugn order dated 20th July 2023. The petition is disposed of. Yes. Dispose.
27. The informant of the case. And before I take to the appointment, I kindly have a chance to.
Entire proceeding course.
Yes, 161. The complainant who initially filed a 168 for declaration of right of interest, confirmation of person and formal release. That is under annexure 2 at page 30.
You are what is your name? You are Hemant Kumar Sahu and Prakash Chandra Jena.
Yes. My name is page 30.
And Pratima Das.
Pratima Das is complaint.
Come to the plaint.
Complaint. Pratima Das was the plaintiff. Hemant was the defendant number 2 and Prakash was defendant number 3. Declaration short form. Confirmation question and formal ignorance. That ended in a compromise. Your lordship will come to annexure 3 at page 30. In 12/11/2016, it ended in compromise and compromise dispute was accordingly passed. Thereafter, my lord, in an application under order 2015, 3 CPC was filed, page 45. And as per the terms of the compromise, the plaintiff brought all the issues. We considered for the plaintiffs there and got it. But before the claim was filed, remember the 160 case was registered. And cognizance and under 163 it was sent to the police and FIR. So now the entire grievance of the plaintiff having been
addressed in this compromise. Then notice has to go. We will see. Notice has to go.
Yes.
Notice to opposite party number 2. Basically, this has already been settled.
Open number 2 only.
Open number 2. Mr. The waive notice and open.
I prayed for stay of further proceeding of the CP case, because now it is proceeding.
Investigation is going on.
No.
As you have stated in your petition, you'll also be kindly turn to page 3. Page 3,
Phase 3.
para 3.
Yes.
Page 3, para 3. The FIR was registered.
Investigation is going on. No question of stay.
No,
That you have made it pay para 3.
but now it is.
No. Oh, it has gone on record that investigation is going on. Court can't stay the investigation.
No, I'm not saying.
Okay, I am giving a thought date, sir. 10th, 11th.
But the notice cannot be written. Because
Oh.
I have to state by, even if I state by speed post, it has to be at least 3 weeks.
No, where is this thing?
Typically, the opposite party is in Bhubaneswar.
Hey, Bhubaneswar, what is this?
Bhubaneswar.
11th. Sir, 11th. 11th.
But a notice on interim application.
I will finish it up that day. Why do you worry? If she comes and says, then we'll finish it up. Offense is very, that's 420, 468 and all.
Now it is.
The same property, belong to same property. I've seen it. Same property, if there is a compromise decree, then where is the question? She will also be not interested. We'll do it. Yes.
28. 28 May, please, my lords.
Here.
My lords, I've challenged an order under section 127 3C of CRPC. But my lord, before going into the merits of my case, my lord, there is a defect, my lord, as per the SR. And that may not be cured at this stage. So, my lord, registry may be directed to
What is the defect?
nomenclature, my lord. Instead of 482, my lord, 227.
Oh, cure the defect then.
My lord, registries may be directed to, my lord, change the
You
nomenclature.
cure the defect, registry will do it. Now the system is changed from second. Don't worry. These are the matter filed prior to second. Second, it might have filed earlier.
Prior
So therefore now system has changed. No direction is required. You file it, immediate cure the defect, things will be done. Yeah, you tell when you want. 12th?
Yes, ma'am.
12th.
Obliged, ma'am.
29. May I please?
The Belgium matter, NBW dated 26/9/23. The Belgium matter, ma'am.
Sorry?
Belgium matter.
Little louder.
Belgium matter, ma'am. NBW dated 26/9/23.
You are saying Belgium matter. How would I know? Belgium. In India, in Orissa, we are there. Belgium, I thought Belgium. What is Belgium is about?
Belgium matter. NBW dated 26/9/23.
When was the bail granted to you?
Bail granted in dated 23/2/21. Same day forwarding the religion.
Where is that order?
My lord, in charge sheet, Annex 2, page 14. Date of arrest, my lord, 23/2/21. Date of religion bed, 23/2/21.
Where is that? 14, huh? Date of, yes. Date of arrest is February 21. On the same day you have been granted bail. And thereafter you absconded.
That someone issue.
When someone issue? 21. Cognizance is taken on 8th. Where is the order issuing NBW? This order, huh?
And page 20, order dated 26/9/2023.
They let him surrender.
Yes, yes.
Allowed. Allowed that. Yes. You will surrender within 1 week.
7 दिन surrender करो तो
1 week, huh? From today. 1 week means no. 1 week there are 2 holidays, huh? 10 days.
10 days
10 days. Surrender in 10 days, huh? Right down. Next.
30. Might please, Your Lordship. On the petitioner hearing, I challenge the order of cognizance dated 2/5/2022, passed by the learned STGM Baripada in city case number 570/2020, wherein the learned magistrate has taken cognizance for commission of offence under section 506 of IPC against the petitioner, my lord. My lord, the
mic is functioning.
My lord. My lord. My lord, the affair allegation did not suffice the ingredients of section 506 of IPC. In order
Forget what about charge sheet?
Charge sheet, my lord. In charge sheet also, the allegations that were made in the affair that has been that is different. The statements in the
161 statement and
also
all.
506, my lord. Charge sheet has been submitted for 506, my lord. And the allegations, in order to constitute an offense under section 506 and that to constitute a cognizable offense, it has to satisfy the ingredients that are provided in 506 part 2 of the 506, my lord. However, in the allegation that is made in the FIR, the
FIR, forget now. Talk about the
Charge
FIR is
sheet,
not everything.
page
Charge sheet,
18.
Talk about the charge sheet.
Right.
80.
Page 18.
18.
80.
18.
Well, I have annexed the charge sheet as well as all the 161 statements of all the charge sheet witnesses, my lord. Even from their allegations.
You want that a trial should be conducted here?
No, I don't want the
file
trial,
everything and there have to cross
in the
examine.
prima facie, my lord, the prima facie materials, the very allegation, my lord, at the stage of the only the allegations.
What is the offense?
506, my lord, the criminal
How many accused are there?
Only one accused, my lord.
506. Let us see.
The criminal intimidation, my lord.
Let us see. 506. Come to the page 18.
18, my lord.
Read.
My lord. Brief facts of the case, my lord. Page 18. Is that on 8/4/2022 at 9:40 p.m., informant Avik Chatterjee, lead engineer of Electricity Department, Baripada, presented a written report at police station alleging therein that on 6/4/2022, he along with his enforcement team went to Takatpur area to detect unauthorized and theft of electricity. The team was proceeded to consumer number so and so, which was recorded in the name of late Hemachandra Patnaik. It was detected that the consumer is using the electricity of 3 kW by tampering the meter. After verification, such unauthorized use of electricity and inventory report was prepared on the spot, and after obtaining the signature of the representative of the consumer, a copy of the report was given to the representative of the consumer, Srimati Gitanjali Mahanti, as per provision of section 126(135) of Electricity Act 2023. Basing on this report, Inspector B.K. Senapati, IAC Baripada Town, registered the incident case and directed me to take up its investigation. During investigation, examined the informant as well as other witnesses and recorded their statements under 161 CRPC. Visited the spot and prepared a clear spot map. The witnesses were well proved the occurrence in this case, as there is prima facie case against under section 506 IPC is well made out against accused Satyajit Patnaik. Hence, as per provision of law, notice under section 41 CRPC was served upon him with a direction to obey the terms and conditions of the notice. This case has been supervised by IAC Baripada Town PS. And after complying the instructions of SO, I discussed with my IAC regarding the progress of investigation of the case, who directed me to submit charge sheet under section 506 IPC against the accused Satyajit Patnaik in this case. Investigation of the case has been completed as there is sufficient evidence under section 506 is well made out against the accused Satyajit Patnaik. Hence, I submitted charge sheet by.
What about this this thing? Section 126, 135 Electricity Act?
That is under Electricity Act, my lord.
That's a separate one.
That is separate. That doesn't come under the no police case can be registered for.
That is going on.
That is going on
against the same accused.
That the meter has been registered in the name of the grandfather of the present accused, my lord. They have alleged in the FIR, my lord. In the past, when in the first instance when the FIR was present.
Let's see 161 for that inspector. The team which visited the place.
Case number 21, my lord.
21. 21 years.
So-
21 is
Sorry,
FIR.
sorry. my lord. Page number, it starts from 25, my lord.
25.
Ma'am.
Yes. Read it. Statement of Abhik Chatterjee.
Abhik Chatterjee.
Hmm.
He was the lead engineer who states to have
Read
gone
it.
on the raid.
ମୁଁ ଆଜି ଉପରୋକ୍ତ
ମୁଁ ଆଜି ଉପରୋକ୍ତ ଠିକଣା ଅନୁସାରେ ଏହି
जोर से पढ़ो टिके
my lord,
जोर की पढ़ाନ୍ତୁ।
ମୁଁ ଆଜି ଉପରୋକ୍ତ ଠିକଣା ଅନୁସାରେ ଏହି ମୌଖିକ ବୟାନ ଦେଉଛି କି ଗତ 6/4/2022 ତାରିଖ ମୁଁ ଆମ ମ୍ୟାନେଜର ଉଦୟ ନାରାୟଣ ପାତ୍ରଙ୍କର ନିର୍ଦ୍ଦେଶ ମତେ ମୋର ଏନଫୋର୍ସମେଣ୍ଟ ଟିମକୁ ନେଇ ତକତପୁରର ଇଲେକ୍ଟ୍ରିସିଟି କଞ୍ଜ୍ୟୁମର ଲେଟ୍ ହେମଚନ୍ଦ୍ର ପଟ୍ଟନାୟକ ମିଟର ଚେକ୍ କରୁଥିବା ସମୟରେ ହେମଚନ୍ଦ୍ର ପଟ୍ଟନାୟକର ନାତି ସତ୍ୟଜିତ ପଟ୍ଟନାୟକ ଘରୁ ବାହାରି ମୋର ଏନଫୋର୍ସମେଣ୍ଟ ଟିମର ସମସ୍ତ ଷ୍ଟାଫ ମାନଙ୍କୁ ଚେକ୍ କରିବାକୁ ବାରଣ କରୁଥିଲେ। ତେଣୁ ଆମ୍ଭେ ଉକ୍ତ ଜାଗାରୁ ଅଫିସକୁ ପଳେଇ ଆସିଲୁ। ଆସି ଜାଣିବାକୁ ପାଇଲୁ ଯେ ଉକ୍ତ କଞ୍ଜ୍ୟୁମର ଦ ମିଟର ନମ୍ବର କରି 17 ମାସ ଧରି ଅଧିକ 54 ୟୁନିଟ ଲେଖା ଇଲେକ୍ଟ୍ରିସିଟି ବ୍ୟବହାର କରିଛନ୍ତି। କିଛି ସମୟ ପରେ ସତ୍ୟଜିତ ପଟ୍ଟନାୟକ ଆମ ଟିପିଏନଓଡିଏଲ ଅଫିସ ବାରିପଦାକୁ ଆସି ଅଫିସ ଭିତରେ ମତେ ଓ ମୋର ଏନଫୋର୍ସମେଣ୍ଟ ଟିମକୁ ମାରିଦେବାର ଧମକ ଦେଇ ପଳେଇ ଗଲେ।
तो मारी देवार धमक तो देला आपण
My lord, I'll show you lordship how the allegation is improbable, my lord.
those things will be tested
My
in the
lord,
trial. No.
my lord, at the stage of the FIR, the
No,
FIR did not
no.
disclose a cognizable offense.
There is 161 statement saying that you have threatened them.
My lord, the allegation is that on 6/4, I was not present on that day.
All these things are matter of alibi. You are again taking alibi now.
My lord, I am a PhD scholar. On that very date, I was appearing for my PhD exam.
That is a plea of alibi.
Well, I have annexed the answer sheet, my lord. My answer sheet.
You don't understand. These are the defense plea. How can I help you? Tell me.
Well,
If the 161 statement you unnecessarily read it and
my lord, the police could not have investigated beyond the stage of FIR, my lord. The FIR itself could not have been registered, my lord. My lord, with your kind permission, my lord. Also, in the case of State of Haryana versus Bhaganlal, the court has clearly stated that if the police has unfettered powers at the stage of investigation, but if the very allegation do not disclose a cognizable offense, the police could not use its
you
investigation.
read the 161 statement.
Well, at the state, 161 statements have been exaggerated, my lord, and that I am saying by producing the marks, the answer sheet, my lord. On that very date, I was appearing. My lord may also seek for instructions whether this mark sheet is a genuine or not from the Sambalpur University, my lord.
What is he doing, this boy?
He's a PhD scholar. He now is a teaching in a university, government college, my lord. And the difficulty that this person is facing, that whenever he is applying for a regular job, the column asks him whether you have a criminal antecedent.
That's the problem.
My lord.
Spur of a moment, he might have gone and threatened them.
Yes.
That
Spur of
might
the
have
moment, yes.
happened.
That
So
obviously
in what way we can help him? You tell me. Young chap. He will be acquitted. Obviously, he will be acquitted. So in what way we can
now
help?
these are the official witnesses.
I know that.
These are the official witnesses. So if private,
You think over what to do. In
Your
what
lordship-
best way we can help him.
at present, your lordship may issue notice and stay the proceeding. At present, this is my.
I'll not stay the proceeding.
Otherwise, there is no case, Lord. Because entirely 161 statement along with other witnesses.
Why can't
statement,
how many witnesses? There are 2-3 witnesses only.
other witnesses are there?
Charge has been framed.
Well, no charge has been framed. Even the cognizance has
It's a
just
case.
taken. A year has lapsed from the date of cognizance, my lord.
Other witnesses are there. 1, 2, 3.
All
4,
2-3 witnesses, those who have
Five.
gone in that team.
No, 5. Total 5. He has annexed 5 statements.
So why can't we target the trial and
Yes.
everything is
Yes,
finished,
yes, yes.
and at least he will be free
Yes.
within 2-3 months.
Yes, yes.
That's the best way of doing it.
Well,
You will
at,
be
sure,
acquitted.
thanks,
and
sir.
at this stage, your lordship can also interfere, my lord.
See, the stay will not help you. Why don't you understand? The matter will be pending. It will be hanging on your head always. It is better that within 2-3 months finish it.
That is always better. Matters should hang on, but and your lordship also should be generous in granting stay.
Now, what is happening is granting stay is clogging the system.
Lord, I'll tell your lordship one thing. Even if your lordship doesn't grant stay and your lordship targets it, I doubt whether it will be completed. Extensions will be asked for before your lordship.
Now, I will write no extension will be given.
Even if your lordship writes that, extensions will be.
But still, there will be a pressure on the trial court that at least this. See, the problem is this is a young boy. He might have, in the spur of moment, he
Yes,
might
yes.
have done
And
that.
in this case, my lord,
In getting a settlement done out of.
No, the official witness.
এটা official witness তো ଅଛନ୍ତି ସେଥିପାଇଁ। A total six.
Everybody want to help you.
Yes, समझते हैं. We also. Stay the proceeding.
So let's go by that. Everybody says stay, huh? Yes. Stay trial court proceeding, issue notice.
Issue notice
and stay. Whether it will help you or not, I don't know, but they have a larger experience in
Informant is
this course.
Informant is not a party.
Stay. And but a short date.
You have not made the informant as party.
Yes, issue notice to the informant. Have you completed?
Not.
On the oral prayer, the petitioner is given liberty to implead the informant.
As opposite party number 2.
As opposite party number 2. Amended memo parties may be filed during the course of the day. Issue notice to the opposite party number 2. In the meantime, the proceeding before the court below arising out of so and so is stay.
Yes.
Next date is 19.
Right.
You tried serve. If something can come out, we can settle. We will persuade the informant not to proceed. Bring him and finish it up.
Yes, that is.
A young boy, unnecessary.
Yes.
His career
That is
will do it.
31.
Challenging the order dated 21/5/2020. What happened in this case, my lord? Initially, FIR was lodged under section 506, 350. All are tribal magistrate. Annexure 2, page 9.
Annexure 2, page
9.
My
lord, the petitioner number 1 was arrested on religion bail, and others are religion bail by the.
How many?
My lord, on 41. 41 share.
Yes.
Subsequently, my lord, charge sheet submitted under section 307. Therefore, Lord and Magistrate has.
And 323 to 324 was there.
My lord.
So it became 307.
My predicament is, my lord, that since 307 is added, my lord, the Lord and Magistrate has no power to release me on bail. As at the time of FIR, it was under section 506. All are tribal and magistrate.
So you have bail insofar as the minor offences are concerned. Now 307 is added.
My lord, my humble.
And what is the remedy?
Once a bail, my lord, always bail.
But what is the remedy?
Remedy, my lord, as per the Sushila Agrawal case, my lord.
Not 482 in any case.
Yes, my lord. Your lordship is suggesting for 430? No, 430 is not maintained. Once charge sheet submitted.
Then this 482 is a bail application in disguise.
It is not a bail application. I am suggesting, my lord, I am praying, I will surrender before the court below as per the direction. And the court below should follow the Sushila Agrawal case.
That Sushila Agrawal was in a bail petition.
No. Here, what happened, my lord?
That is not arising out of a 482 petition.
Sushila Agrawal is also a bail application. Yes, 482 application.
It's not a 482.
When a higher offense is added, what is the remedy? If a petitioner on bail during the investigation and subsequently charge sheet added, what is the remedy? My lord, in Sushila Agrawal, my lord,
the remedy is 438.
No, my lord, 430 is not maintained. Then your lordship may dispose of, I will apply 430. But as per my submission, 430 is not maintained. Once I have already religion bail. So there is no apprehension of arrest.
Added offense, you can very well go ask for bail in 438. 438 also.
No, madam, this is not maintainable.
You show me how.
My senior.
Sir will tell.
Sir,
in the added offense, why not 438 maintainable?
My submission is this. Your lordship will look at the CRPC. The CRPC says that when a charge sheet is filed, the court is either to issue a summons or a warrant. Usually, the lords, in such cases, when higher offences are added, court sometimes issue coercive orders, for which that order is challenged, which your lordship can dispose of saying that in view of Sushila Agarwal, the
No, no,
process
no,
would
the
have
question
been-
is, if higher offences are added, no coercive action, no coercive process are issued by the court, and the apprehension lies.
If no
If
coercive
apprehension
process
lies,
has been issued, there is
apprehension
no
lies, why not 438 is maintainable?
There is no apprehension if no coercive process is issued.
But section is added.
Section is added.
Section may be added, my lord. But
Then
that, my lord,
there is a likelihood that coercive process will be
no,
issued.
from the very beginning, my lords, the courts have said that once bail is back, whether it's anticipatory bail or even custody bail, that bail continues till the end of the
That's
day.
right. That's
That
right.
is 88 free legal aid versus 10.
Right.
And Sushila Agarwal has said that where somebody is released on anticipatory bail for offences, and when charge sheet is filed, a graver offence
Is added.
charge sheet is added, then also the same anticipatory bail should continue, and he should be deemed to continue on bail throughout the proceedings.
If it is a 307 and it becomes 302,
Then
Then my lord, magistrate has to decide, my lord, whether custodial interrogation is necessary or not.
That will Satyendra
until will come.
until is the answer.
Answer, my lord. If the magistrate
Give
satisfied.
Sushila Agarwal then. Give Sushila Agarwal.
Sushila Agarwal judgment, my lord, I have.
Get it after lunch.
After lunch, my lord.
Get it after lunch.
সেটা
We'll see.
নেই,
Is there? It's lying in my table
Page
also.
one,
But get
page
it.
one
Get
of
it for you. With relevant para. But we.
Sushila Agarwal might be mad.
Which para you want?
after lunch, I will.
Yes, after. Because according to me, 438 is maintainable. 438 is maintainable. With observation, you can.
Not required at all, my lords. If
That
your
require is
lordship
not-
can
It is required or not is a separate issue, but 438 is maintaining.
But our High Court view is once you have availed the 430, you can.
Second time for added offense you can't do.
Yes.
that is the view of the apex court also.
So then Sushila Agarwal is the only way out. Okay, we'll do it so that in other matters also it will help. Okay, done. Next.
32. Please, your lordship.
You have now argued in almost all the matters.
My lord, he is the champion of.
And you should leave your matter for others to argue. Now, this is the advantage. If somebody, some senior is there, it is a learning process. Everybody should learn. He is and Mr. Chand, they are the senior people. And we should take advice and learn things. Yes.
Please, your lordship. This 482 application is against an order at
Yes.
annexure 1, my lords, page 13. Refusing to discharge the petitioner company, my lords,
Yes.
which is an accused in TR case number 1 of 2008 along with others. Now, my lords, the facts leading to this petition.
That is interlinked private limited.
Yes.
Yes.
The facts leading to this petition is that a FIR was lodged, my lords, by the bank officials of Indian Overseas Bank, my lords,
Yes.
which was treated as a cognizable offences, my lords, and investigation was taken up. That FIR culminated in a charge sheet which I have annexed as annexure 2, my lords. And in the charge sheet, my lords,
Yes.
one Surendranath Das, one Ramkrishna Mishra, one Ramkumar Sethi, and others were other bank officers were named as accused, and the firm Interlink Private Limited, whose managing director is an accused, was also named as an accused. And this charge sheet was submitted against these accused persons, my lords, under sections 120B, 420 and 477A.
Okay.
Now, the interlink, the company came up in a 482 application before this honorable court, and this honorable court was pleased to observe that the charge framed against the company under 477A IPC was not sustainable. And so it was remanded back. And further framing of charges afresh, my lords, the matter was remanded. Thereupon, my lords, the petitioner filed a petition for discharge, and this petition for discharge having been rejected, a 482 petition was filed in this honorable court. That 482 petition, my lords, notice was issued and interim orders were granted. This 482 application, my lords, was listed before the honorable court, my lords, and stood dismissed for default. It was restored, my lords. After restoration, my lords, the matter was listed once again, and for the second time it was also dismissed for default. When that was dismissed for default, my lords, a petition for restoration was filed. And that petition for restoration was taken up by the court before whom the matter was dismissed for default. And that order, my lords, is at page 97 of the brief. Would your lordship see that? Order?
97.
Page 97.
Yes.
It's order dated 5/5/2022 in CRLMA 78 of 2020.
Yes.
I'll place the order. This is an application for restoration of CRLMC number 1763 of 2011, dismissed for non-prosecution by order dated 25th March 2022. Aforesaid criminal miscase is of the year 2011, wherein petitioner has challenged the order of refusal of his discharge petition. It appears that the aforesaid criminal miscase was dismissed for non-prosecution by order dated 6th November 2021. However, on prayer made, the same was restored by order dated 25th November 2021 in CRLMA 254 of 2021. Again, when no one had appeared on behalf of petitioner on the date fixed, the case was dismissed. Then, Mr. So-and-so learned counsel appearing for petitioner submits that as the name of Miss So-and-so learned counsel was appearing in the cause list as the shortened form is quoted, she has missed the list, could not appear before the court. Hence, the aforesaid criminal miscase be restored and disposed of on merit. I am not inclined to do so as this is the second default. Hence, the CRLMA is dismissed. But liberty is given to petitioner to approach this court if cause of action survives by filing a fresh petition. Now, my lords, as on 5/5/2022, when this order was passed, and even till date, the cause of action survives because no charge has been framed so far. So, the petitioner again moved another CRLMA for restoration. That order is at page 99. Next page.
Yes.
The order is at page 100. If your lordship will see that order, paragraph 2, so-and-so for the petitioner while praying to withdraw the CRLMA submits that since this court, by an order passed on 5/5/2022 in CRLMA number 78 of 2022, had granted liberty to petitioner to approach this court if the cause of action survives by filing a fresh petition, petitioner may kindly be permitted to agitate his grievance again before the learned trial court. Mr. So-and-so learned counsel for CBI, however, strongly opposes such prayer by inter alia stating that it's not maintainable in the eye of law. In view of the aforesaid submissions, this court, without making any observation on merits, allows the petitioner to withdraw the CRLMA. Thereafter, my lords, I filed a petition for discharge, my lords. That is annexure 4, my lords, at page 88, to which these CRLMA orders are annexures. Now, in my petition for discharge, my lords, I raised two contentions before the court.
Now you are against that discharge order.
Yes. Now, the two contentions.
This is
that
in
I-
any case a fresh cause of action.
Yes.
So this, the earlier orders will not hurt
Yes.
you because this is an independent 482.
Right.
It has to be examined. So those earlier orders lost its relevance.
Yes.
Right.
Now, my lords, what has happened is the petitioner company is shown as an accused and charge sheeted under section 120B read with 420. Now, what is 120? 120B is an offense of criminal conspiracy, which requires a mental makeup to be there. As juristic person as a company, my lords, my contention was that I could not be charged with conspiring. My director can conspire. My managing director can conspire. But how can a juristic person conspire having no mind of its own? And I further stated that my managing director was also be an accused in the charge sheet in his individual capacity for the same allegations. And therefore, I said that the company cannot be charged for the acts of its directors, my lords. To that, the CBI filed a reply, my lords. If your lordship will see the reply, my lords, at page 102, my lords.
Your lordships, I will accept notice.
Your lordship may see page 103.
Yes. Averment made in para 1 and 2.
No, I have 103. Are matters of fact and no counter offered. However, learned trial court has invoked section 477A IPC against the company Interlink, wide order dated 25/11/2000 Act, because the section is applicable for public servants. But I invoked should read as revoked.
Yeah.
Further, learned court has rightly fixed responsibility over the company for being liable for commission of offences under 120B and 420 IPC by such act of its directors and directed for framing charges, which was challenged and stayed in the Honorable High Court. Now, my lords, interesting part is paragraph 4. Now, I can understand, my lords, the director being vicariously liable for the offences committed by the company. But now the stand here of the CBI is that the company being a legal entity is vicariously liable for the acts of its directors. This is the stand they have taken at paragraph 4 and 5. What they say is this, that the averments made in 3, 4 and 5 are matters of facts, true to the effect that Surendranath Das, being managing director of the accused company, was operating current account number such and such at IOB Paradip branch and has defrauded funds entrusted to the accused company and thereby committed offense punishable under 120B and 420. Surendranath Das has been charge sheeted. He will face trial. I have nothing to say. But what they say now thereafter is, accused company being a legal entity represented by its managing director Surendranath Das is vicariously liable for offences committed by its managing director and equally liable for punishment for commission of offences by its managing director. Then your lordship may see para 6, that the averments made in para 7 is not true to the extent that IOB Paradip credited funds in the bank account of the company represented by its managing director Surendranath Das. Same was misappropriated by Surendranath Das. Since company is the legal entity, it is liable for commission of offences represented by its managing directors. Again at para 5 they say, a company is a legal entity oblique person. Company performs day-to-day business.
How the trial court deals with it?
The trial court has glossed it over and just accepted it. My lords may look at the
Annexure 1.
impugned order at Annexure 1.
Yes.
The court writes, para 17, page 17, my lords may see.
Yes.
The court writes, on the other hand, the CBI has filed reply to the petition filed by the accused it is contended by learned PP that this court rightly fixed responsibility over the accused company for being liable of commission of offense under 120B and 420 by such act of its directors and directed for framing charges against the accused company by order dated 29/4/2011. It is further submitted that accused Surendra, being the managing director of the company, was operating CA number 459 at IOB Paradip and had defrauded funds entrusted to the company, thereby committed offense punishable under sections 120B and 420 IPC. Accused company, being a legal entity represented by the MD, Surendranath Das, is vicariously liable for offences committed by the MD, equally liable for punishment for commission of offences by its MD. Then the court writes, the next page, page 18, your lordship may see, 4 lines from the top, 6 lines, your lordship may see. The sentence begins, the accused.
Yes.
The accused petitioner has filed a discharge petition. Same was disposed of by order dated 29/4/11, wherein this court observed that there is strong prima facie case under 120B and 420 IPC against the firm represented through its managing director, Surendranath Das. Accordingly, petition was rejected. It is found that against that order, accused challenged it in CRLMC 1763 of 2011 before the Hon'Ble High Court, which was dismissed. It is well settled law that when allegations are baseless, without foundation, and no prima facie case is made out, it is just and proper to discharge accused to prevent abuse of process of court. If there is no ground for presuming that accused has committed an offense, charges must be considered to be groundless. In the present case, this court has already held materials available on record prima facie source, prima facie case under 120B and 420 IPC against the accused company. In the present case, earlier petition filed under 239 was rejected by this court on 29/4/2011. Same order is in force. Further, from the case records and documents, it is found that there is prima facie materials and sufficient ground to proceed against the present accused. Considering the present facts, this court comes to the conclusion that accused petitioner interlinked accused number 7, represented through its managing director Surendranath Das, cannot be discharged, and he has rejected. Now, while doing so, my lords, he has not considered one thing. I'll ask your lordship, my lords, to kindly look at the charge sheet at page 32, my lords.
Yes.
Now, the charge sheet shows in the list of accused persons, number 1 is Surendranath Das.
Yes.
Bracket रे लिखा है private person, bracket रे लिखा है FIR named. तापरे 2, 3, next page रह गया 4, 5, 6.
7 is the interlink.
Interlink Private Limited through its managing director Surendranath Das. Now, my question is this: if the company is vicariously liable for the acts committed by Surendranath Das, suppose there is a conviction, and Surendranath Das is sentenced and the company is sentenced. Company will not go into custody. Surendra Das will go. Will Surendranath Das go to jail for 2 terms?
Because he is accused in a personal capacity as well as
yes. Now, so far as a company or corporate entity is concerned, the law is well settled in 305 CRP. The company has the discretion to appoint whomever it wants as its representative. But here, that has been foreclosed by the CBI authorities. They say interlink has to be represented by Surendranath Das. Surendranath Das is already an accused. And how can the company be vicariously liable, milords, for what the accused has committed? A director.
Yes, I understood. Yes, Mr. Naik, Sarthak.
Your Lordship, I'll accept notice and I'll file a reply to it. Let the matter be listed after 4 weeks, Your Lordships.
Why 4 weeks? Small matter. For you, it is very small matter.
3 weeks, Your Lordship, then. Because, Your Lordship.
See, now he has already extensively argued. Better that you give a written submission and whatever judgment you have, Let us finish it up next week.
Your Lordship, because the reply needs to be vetted through some sources, Your Lordship, 15 days time may be given. I'll argue the matter also, Your Lordships.
Okay, then you tell me then on the 29th or 30th?
30th, Your Lordships, 30th January.
30th. But you give your judgments and what you call a short synopsis, list of dates rather, because there are many petitions earlier filed and all.
Can it be 31st?
31st. He is requesting for 31st. Let it be 31st.
What my learned senior will do.
If you notice to the opposite party, Mr. Naik waits notice. Seeks 2 weeks time to file response to the petition. Mr. Naik also seeks time to file a written submission along with the relied upon judgments on 31st. Okay. You can also give some judgment if you have.
Your Lordship, I'm sorry, Your Lordship, 31st, Your Lordship, have some difficulty. Can it be the first week of February? Just my junior told me.
Okay, 31st, first week of February. Any date?
Any
Which
date, Your
suits you?
Any day.
3rd February, Your Lordship, 3rd February.
3rd February.
3rd February is Saturday.
Saturday. Oh, Saturday you are in Cuttack. That therefore. Saturday, Sunday you are in Cuttack. So therefore he wants.
Third I'm coming. 2nd February, Lordship.
2nd, okay. 2nd. Okay, 2nd.
Till then, the court will not insist on my appearance.
Through VC.
No, VC I will represent. But if the court will frame a charge,
no, Surendra is in any case appearing. Company can't court appearing.
It will not insist upon.
Insist upon the company to come.
Yes.
Company is represented through Surendra. So that therefore.
So an interim order may be passed that.
No, Your Lordship, but under.
In any case, Surendra is appearing in the. According to you, Surendra is appearing in two capacities. In the personal capacity as well. So therefore, in any case, he will appear. For Surendra, if you want, VC can appear.
Let the court not proceed further in the matter till the 2nd, till the 3rd of.
But Your Lordship, under 19.3 PC, no court shall stay the proceedings under the Act. That is a specific bar.
I know that PC.
PC Act no,
120.
IPC.
IPC 120B and 420.
No, if Your Lordship will come to that order. If Your Lordship may kindly come to the discharge order 882101.
Anyway, I am not saying it is short date. I am not saying. I am not saying anything.
Yes,
you file it and on that day we will dispose it up.
Let a notice in the interim application.
Notice on interim application as well. Notice on interim application as well. Okay. We will finish it up on that day.
Yes, Your Lordships.
No question of further adjournment.
Yes.
Please make sure that it is done.
I'll be ready, Your Lordships. Yes.
Thank you.
33.
This is a Belgium matter. Petitioner was on bail.
Belgium.
No.
How many times? When you got the bail?
My lord, I have got bail on 13/4/2021.
21.
My lord. 19, my lord. I put an ABLPL number 4193 of 2019, my lord. I have
what is the offense?
No, offense is 506/494.
Charge sheet is filed and you're facing
charge sheet is filed, my lord. I am regularly facing the trial, and on that
page 16, my lord, arrest and release of date has been given. Page 16. 1/6.
What is where is the order of issuance of warrant?
1/6, my lord.
7 annexure 1.
7 annexure 1. Yes. All right. We'll cancel it.
Yes.
The petitioner is facing trial in so case. He has been enlarged on bail on enlarged on bail on such day by the coordinated bench of this court by its order dated dash in
25/12/2020.
25/12/2020.
12/2020.
25/12 number, case number
ABLPL number, my lord, 4193 of 2019.
Good, sir. However, after availing bail, the petitioner appears to have defaulted in appearing in the trial court.
Yes.
Therefore, on 31/10/2023, NBW has been issued against him. Good, sir. The petitioner is aggrieved by the state order dated 31/10/2023 and seeks interference of this court. Full, sir. Heard learned counsel for the state. Full, sir. The learned counsel for the petitioner on instruction undertakes that he would be appearing before the trial court on each and every date appearing without fail on the basis of on the basis of the state undertaking. The order dated 31/10/2023 is set aside, and petitioner is directed to surrender before the court on
Within 10
by
days.
within 10 days hence.
This is also same. Belgium.
Same Belgium.
Same.
Yes.
Same story.
Nahi, Belgium. Granted bail on 16/4/2011.
11.
And warrant issued on 15/1/2015.
Charge sheet filed. The petitioner is facing trial in such and such case, and he has been granted bail on such and such day. He is not appearing, so.
Lordship is directing the surrender on religion.
Yes.
Surrender same bail.
Yes. Surrender religion bail quoted.
Yes. Problem.
35.
Yes.
Item 31 that Sushil Agrawal case.
Monday. But you have to tell the other side.
Yes.
Monday.
Monday.
Yes. 37.
Item 30, I will be permitted to correct, implicate the informant in the court.
Well, in which case your lordship directed me to help in some way.
Give a memo.
He may be permitted to implicate the informant as a party in the presence of the court.
That I have already dictated.
ନାଇଁ ସେ ଫାଇଲଟା ଦେଲେ ସେ ସେଇଠି ଆପଣଙ୍କ ସାମ୍ନାରେ
ଇମ୍ପ୍ଲିଟ୍ ଟାଇପ କରି ଆଣିଲେ ପ୍ରୋବ୍ଲେମ
ନମ୍ବର ହବାକୁ ପଡିବ ଆଜି
ନାଇଁ ଟାଇପ ରୁ ଆଣିକି ଲଗେଇ ଦିଅ
ମେମୋ କରି ଦେଇଦେଲେ ମେମୋ କରି ଦେଇଦିଅ
ଏମାଣ୍ଡେଡ ମେମୋ ଅଫ ପାର୍ଟିଜ ଟୁ ବି ଫାଇଲ୍ଡ କହିଛି ନା ମୁଁ ଏମାଣ୍ଡେଡ ମେମୋ କରି ଦେଇ ଦିଅ ଉପରେ ଲେଖି ଦିଅ ଏମାଣ୍ଡେଡ
ଖାଲି ମେମୋଟା କରି ଦେଇଦିଅ
ପାର୍ଟି କରି ଦେଇ ଦବ ଲାଗିଯିବ ହଁ ଠିକ ଅଛି ଦେନ୍
ଠିକ right
yes
item 36 madam I am from the opposite but I have received the copy of the chair's matter.
2 weeks 2 weeks 36 2 weeks
36 2 weeks
37
37 I am there.
Yes, it is to be argued then.
Your my lords, it has been heard at length, but now since it is coming up before your lordship for the first time, what has happened here is this, my lords. A complaint was filed against me, my lords. The petitioner before...
If it is to be heard, then after lunch.
After lunch, I will be in a little bit of a...
Then take appropriate time.
Can we do it next
week? Next week. Which date?
10th. Any day.
It should be convenient to you.
10th or 11th?
11.
There is an interim order.
Interim order to continue. Interim order to continue. So what? They are not taking interest. Let us see what is this petition. Give it in February, March instead of you dismiss in default, then again application will come. Give it and mark this petition. It will give memo, don't respond.
But that may be mentioned in the order, but non-appearance maybe.
I'm doing that.
You do
Non-appearance. So that it will
in the
be.
interest of justice adjourned.
Right.
Because once they will not come again, they'll keep
My
on
lord.
mentioning things.
Item
Yeah.
4.
Same.
Item 6.
Yes.
I have filed this application for direction for early disposal of the case, my lord. So in this case, my lord, charge has been framed in 26/12/2022.
2022.
My lord. Till date, no witness has been examined.
1 year.
1 year more.
What is the offense?
Offense, my lord, 341, 323, 294, 506 by 34 IPC and a section 31 RS and a 2V of SC and ST POA.
When the charge sheet was filed?
My lord, charge sheet submitted on 16/8/2022 at page 17 plus. Order, that is 16/8/2022, page 17. Letter, charge sheet is received today from.
Charge framed. But the FIR is 21.
Yes, ma'am. FIR is 6/12/2021, but special GR case number 3 of 2022. That means the last day of the 2021, the FIR was registered.
What is the stage? Charge is not been framed. What?
No, charge framed, my lord.
Charge
framed.
How many witnesses are there?
26/12/2022.
That should not there, madam.
Charge sheet copy is not.
How many witnesses are there?
Charge sheet copy is not with me. I have only
Then
another-
you must know now. Then if there are many witnesses, if I fix the date
Madam.
time, then it will be
Lots,
problematic.
lots, no,
So
direct
I'll give
expediency.
that innocuous order.
Lots, no, direct expediency.
That I'll do. Kali karo exam. Charge is FIR is not in the charge is that we will do.
Item 19.
And it is very costly, it's not by CD right?
Item number 19.
19.
Yes.
He's saying yesterday list.
Yesterday list 19 that plus a speed display.
19 is good.
Well.
Item 15.
My lord, I have removed the defect. I pray for Monday, my lord. I have already removed the defect.
Yes. What is this matter? You want to argue or not? Have you ready?
Monday. No, ready.
You're not ready.
No.
Try and argue. If anything can be done. You are asking for cognizance. Order of cognizance. Annex 8. Annex 8. Okay. Do you have any idea about this case?
No.
On merits?
No.
No. Next week. Next week? 12.
Item 16.
Please.
Yes.
In this case, the petitioner challenged the cognizance order taken against the petitioner. The in persons to GR case number 2.0. Now here the petitioner had the case before the Supreme Court and there was an interim order but unfortunately during the corona period I couldn't able to, since I affected corona, I couldn't able to come before this for which non-appearance case was dismissed. And that's why I filed this early restoration of the case.
And in that case, the court was pleased to permit me to file the case if there is any perversion.
Where is that? Where is that order?
The order has been reflected in the CRLMA, and this is the copy.
You have not placed that on record.
Well,
That's not placed on record. That order is not placed on. Where have you said that? Which paragraph? Earlier petition has been filed bearing number so and so in which the stay order was granted. What was that? The same prayer?
Simply.
Same order channels.
That's it.
Same order.
Paragraph 7.
Here in paragraph 76. I've stated that earlier the petitioner had filed the case bearing serial number so and so, in which the stay order was granted. The matter was taken up during COVID period, so and so, wherein the counsel for the petitioner could not able to attend the court for which the case was dismissed on default. If petitioner filed the case serial, so the copy is there. 180.
What is the stage of the trial now?
Till date, nothing has been done.
After cognizance, nothing has been done.
Nothing has been done. Because there is a stay order granted by this one.
A stay order was vacated long back. This is order. This order is
till date, nothing.
August 2022.
My lord.
Stay order-
Arising out
stay
of
order-
complaint case, my lord.
It's a complaint case.
Complaint case.
He has
The husband of the fact of the case is that the husband of the informant, that the complaint case, who has filed the complaint case, he had borrowed some money from the petitioner, and he did not pay that money, and he gave a check, and that was bounced. The case was filed. Therefore, the conviction was he was convicted. That was appeal was filed by that person. That was rejected on the ground that it is been deliberately he bounced the check. That's why thereafter the wife of the petitioner, the wife of the that informant filed the case, stating there that this action has been done. But during that period, the petitioner who is working as the peon of that high school, he was on duty. The headmaster has given the certificate that he was on duty.
No, that's all these things are correct. But the problem is you have challenged the cognizance order. And that CRLM has been dismissed.
It's due to fault.
Whatever, dismissed in default, restoration was moved, restoration is rejected.
No,
restoration application is rejected.
No,
What no? That's what it says. It says, as the ground stated in the petition is not convincing, the prayer for restoration of criminal so-and-so is rejected. It is rejected. You are banking upon the last paragraph, which says that, but liberty is given to the petitioner to approach this court if the cause of action survives by filing a fresh petition.
That's why
that indicates that survive means unless charge is framed or some
supervening circumstances
is attending in the trial, then only you have a fresh cause of action. On the same, once your challenge has been rejected for any reason whatsoever, how can you maintain
same order?
Merely because that observation is there.
That will be rejected on the ground of non-appears.
Whatever, it is not restored, then it is gone.
Since
wait till why charge is not framed too far?
Since arising out of complaint case, my lord, for that reason I have no instruction.
Take the instruction.
Next more. See, he added the complaint case.
How many witnesses are there?
Only 2 witnesses. The complaint case, page 9, may kindly see.
No, where is the complaint case?
57.
FIR, copy of FIR.
Once is complaint case, complaint petition.
What is this copy of FIR then? 33, 34. What is this?
Complaint page 9.
What is this FIR then? Annexure 5. What is Annexure 5?
ଆଉ ଗୋଟେ ଏମାନଙ୍କ ତରଫରୁ ତାଙ୍କ ନାଁରେ କେସ୍ ଫାଇଲ ହେଇଥିଲା ନା ନାଇଁ ଆନେକ୍ସର 5 ତ ଛୋଟେ
Annexure 5, that is 227/2010, the wife, the informant filed the case, this case. It is
it is a complaint case, and under section 156(3), it was directed to the police to take the investigation. The police registered the case.
There are from the charge sheet.
This case is arising out of this page 9 connection, this complaint.
No, page 33, answer 5, where the petitioner is the accused. Page 33.
You are writing this copy of FIR. Vasudevpur PS.
1, 2, 3, 4.
It's not visible also. It is an FIR, it's not a complaint case.
No. There are first she filed the complaint case before the court, and as per the direction under section 156(3).
You say that, na? Then it is a case under 156(3), FIR has been lodged.
Yes.
Then once FIR is lodged, it is no more a complaint case. It is a state case.
Now that is
A state case.
Yes.
Then he is saying FIR is, the investigation has been done. Charge sheet is filed. Charge sheet, where is the charge sheet?
Charge sheet is not filed, my lord. 6/9/2010 charge sheet filed.
Where is the charge sheet? You are not enclosed.
Enclosed.
You want quashing of something and you don't.
NSO 7. That is the charge sheet taken. Cognizance taken against the petition.
Cognizance is taken on the what? FIR.
Basing upon the charge sheet.
Where is the charge sheet?
I have no charge sheet.
And you want quashing. And this is the second petition. These are minimum documents. 173 report has been filed.
Obviously, it may come next week. I will bring that certificate of the charge sheet.
There is 164 statement also. Where is 164 statement?
164 statement.
That she repays 44. 161 sheet.
161. Say the 161.
I'll dispose it up and with a observation that it should be expedited.
Minor.
Trial should be expedited. There is nothing in this case. You can't repeat the petition.
The expedition. 2010 case, my lord, trial. 2010 case. Year 2010. Trial may be expedited.
That's
for that interest.
What is the prayer? See, petitioner in this petition has how many petitioners?
Only one.
Petitioner in this petitioner has invoked the jurisdiction of this court under 482 CRPC, challenging the cognizance order dated 6/9/2010, passed by
Land JMFC Vasudevpur.
Land JMFC. What is this?
Vasudevpur.
In
the district of Hon'Ble.
In GR case number 227 of 2010. 2010. Next program. Earlier the petitioner had approached this court challenging the state order, challenging the same order by filing CRLMA number 188 of 2022. So, the said petition was dismissed for non-prosecution. So therefore, an application for restoration being CRLMC number.
No, one thing. First, I filed CRLMC.
What I'm saying.
Exact
CRLMC number 3499 up to 2010, seeking restoration of the petition. The coordinate bench of this court, wide order dated 12/8/2022, was pleased to pass the following order. Following order. Purely. Full stop. Next paragraph. Banking upon the observation made by the coordinate bench in para 6 of the order, the petitioner has reiterated the prayer in the present petition. So this court is of the considered view that the petition is not sustainable. However, considering the fact that the present case has been is pending pending trial before the JMFC court Vasudevpur since 2010, it would be appropriate to direct the trial court to dispose of the to expeditiously dispose of the conclude the trial, expeditiously conclude the trial. The petition is disposed of. Yes, next.
Asking of my lord and friend.
15. Okay, how many matters are there now?
10 matters.
Huh?
10 matters.
How many remain now? Chalo, 15 letters. No, other people are waiting there.
4 matters.
4 matters. Wait for 5 minutes. Do it. Huh?
Because what has happened?
Urgent is
Another court
already
I have a case.
already urgent matter.
It is already urgent.
No, it's all right. No problem.
No, I wanted to actually argue the matter today. Anyway, you will fix it to 12.
I have already fixed for 12. No?
It
No
may be
problem.
taken up tomorrow, then the urgency is there.
What is the urgency?
Urgency for cognizance has been taken now. The lower court has not allowed any time to proceed. Now, the lower court is not proceeding with the matter.
Cognizance is only taken.
The cognizance thereafter it is a complaint case. Subsequently, it will be evidence.
Notice will be framed.
Normally, it is a general. That will be framed thereafter. That evidence will be.
That's right. What is your?
But as you also kindly see Annex A, it is cognizance was taken on 28/10/2022. That's the whole point. It may be taken tomorrow or on Monday.
Monday there are many matters.
Tuesday or
Tuesday.
Deploy.
Yes.
Item 20.
17 is after that.
17.
Order pass करायचं ना.
Order pass it.
Yes.
I have hurriedly obtained a order from the
Which paragraph?
in first para there is let us say the conviction, it is there. In the second, thereafter the parties went through the several stages of litigation before their disputes reaches the court of a special petition with regard to the impugned judgment delivered by the High Court of Orissa and appellate of the setting aside the conviction in these matters by relying the constant terms on the arrived at the between the parties.
Who says no to it?
Yes, thereafter guidelines will not kindly see. They are morality fixed under the Supreme Court.
You have not followed what I am saying.
What circumstances?
I know that this judgment, I know, that's what I told you, this judgment. At what stage you can settle the dispute?
Yes.
You have to give 15%, 20%, 30% off. You can do it. No, I'm not saying no. You can, in appeal, you can do it. But can you invoke a 482 for that purpose? That is the question. Who says that you can't do it? Of course you can do it. But the question is, you should have filed an appeal and you have done it.
Appeal is pending, my lord.
Huh?
There are appeal is pending.
Appeal is pending.
Instead of going to appellate court, I have straight away file for it.
The appeal is already pending.
My lord.
Appeal,
They have not filed appeal.
Appeal filed, but since he has not submitted the 20% as mandatory.
Not required. Now you have
Therefore,
said
therefore, appeal has been disposed of.
appeal already disposed of.
Already disposed.
Then he can file a revision here only against that. And a revision the settlement we can done.
Where is that disposed of?
Yes, Your Honor. That is it.
You tell half facts. You
Will kindly see. Here, last. Certified copy of.
This is what the appeal is.
Yes.
Dismiss. Last of the dismiss. What have you written? What have you written? You are dictating this report. Very good file. You could have filed a, anyway, we'll do it.
Yes.
They have complicated this one necessary. You have your Wakalatnama?
Yes.
For complaint your
Yes.
file?
Wakalatnama and also receipt he has taken money, all are filed.
That is there.
That is there.
What have you written here? What have you written? Just read it. Okay. After the trial, the Pulwani or the also have been pleased to convict the and sentence him to undergo imprisonment also. After this, para 3 write down. The petitioner challenge the said conviction and sentence order by filing criminal appeal number 8 of 2019 before the Court of Sessions Judge Pulwani. However, Pulwani, the wide order dated 8/8/2022, the appeal was dismissed. Appeal was disposed of. Counsel for the absent. Counsel for the file agreement. Appealant is absent repeatedly. No step is taken on the appeal is dismissed in fact. Disposed of. Directed to deposit an amount of 1,10,000, that is 20% of compensation amount before Pulwani, but the petitioner has not complied. The order is also in part of the several adjournment. Heard the appeal is dismissed. A non-compliance of the order is also against dismissed by the Land Session Court for failure on the part of the petitioner to deposit the
20%
deposit 20% of the check amount. The operator after conviction category at this after conviction now the accused has entered into a settlement with opposite party number 2. The terms of settlement has already been placed on the court. Opposite party so and complainant does not want to proceed with the matter and wish to put fighters to the entire dispute. And dispute 86 turnover dispute. The petitioner has invoked the plenary power of this court under section 482 CRPC and seeks indulgence, despite the fact that the appeal against the conviction and sentence has already been dismissed. already been discussed. Already been discussed. Next paragraph. Having considered the facts and circumstances of the present case, and taking into consideration the fact that the complainant represented through the counsel have agreed to put the entire dispute to quietus and filed joint affidavit. Yes, filed joint affidavit before this court. I feel it appropriate to invoke the jurisdiction of this court under under section 482 CRPC and quash the complaint, quash the
both the order request, order of conviction and also the appeal. Both the order.
Quash the conviction order. Quash the conviction order. Conviction order dated. But trial court full one is conviction and sentence order dated
19/7/2019.
So and so.
So also the appellate order
being amicably settled between the parties. Yes. Being amicably settled between the parties. Dispose. Sure. Without the file and you are satisfied. The receipt. Yes. Where is the receipt?
Receipt I have filed. He has filed. Filed. It is in the record. 8 lakh.
The complainant has made good. They have settled. The petitioner has made good the entire amount, that is 8 lakhs 50,000 and receipt of the same obtained from the opposite party number 2 / complainant has also placed on record. Taking into consideration. Okay.
Nobody there.
Nobody there.
21.
Yes.
Dictionary diploma student man, passing of proceeding man. I have made informant as a party man. But fact of the case is that the petitioner had gone to the house of the uncle, and there is a quarrel between the two groups of the village, and he has been implicated in the case. And
323, what is that?
Only omnibus allegation. Offense, charge sheet has also been filed. 147, 148, 341, 323, 294, 354, 506, 3007, 149 IPC. And injury matter simple. And in the meantime, accused person has been released on bail. I am a student. My limited.
You are on bail?
No, I am not on bail.
You are in custody?
As an absconder. That is submitted Sony has
my limited friends, all the other accused person has been released on bail. I am a student minor. And first hour, second hour, parity so that
in 482.
Your lordship can also.
I can do, but I will not do because then because you are this is kind of a forum shopping.
Yes,
because you won't get some relief somewhere, yes. So then therefore you modify
because to record comply because split up delay petition is a student. I am ready to surrender also. I am
82-83 proceeding initiated.
But that's not there, my lord.
Only my charge sheet has been filed.
No, charge sheet is filed.
That's what the enhanced.
And I have annexed the charge sheet also. Injury also simple matter. All the qualification has been released on also bail.
When are you going to surrender? Then I will.
Lordship, 2 weeks time maybe. I will.
And you apply for bail.
He has filed antecedent bail that has been disposed of.
Rejected. Rejected.
Yes. So I'm a student, so
Yeah, you may be student, but I am ready to give some relief to you.
Yes.
But that is within the four corner of law.
Yes, ma'am.
You tell me why, in what way I can give you relief.
Your Lordship may that within 10 days, I will surrender.
That is again 439 exercise of the power. 438 you failed.
Yes,
You have
sir.
not surrendered.
Yes.
Now you filed 482.
Yes.
In 482, the relief which you have not got there, how can I give it?
Well, 430 is the principle is that well, in the event of arrest. Here you
In the event of apprehension of arrest.
Apprehension of arrest, the prisoner will be released on by the arresting officer.
Hmm.
Here I am ready to surrender before the court below.
Surrender.
So that's
I'll record your statement and dispose it up.
And my lord, but unless
I can record your statement that you
but,
are willing to, and you are a student and offences are not serious in nature. So therefore,
and co-accused person has already been that will be
everything I'll record and dispose it up.
and that will because
He'll take appropriate step available under law.
and also my lord, because 307 is there, so it's trial by court of session, first hour, second hour, so that
These things are beyond jurisdiction. This you Rashmikant Khotua judgment. Just read it. Supreme Court.
Practically,
This is nowhere happens in the country. First hour, second hour, we are not the authority to control the board of the trial court. Why should you do that? First hour, second hour.
because my lord, your charge sheet has been filed, my lord, and it's student. my
File,
lord.
you should.
And so that will be considered so that.
What is the allegation?
Allegation is that while the my lord, funeral ceremony of the informant was going, mother of the informant was going on, petitioner along with 20 others assaulted and abused in slang language.
What was going on?
The funeral ceremony of the mother of the informant was.
Cremation ceremony.
Yes, sir.
Auspicious ceremony. Sudhikriya.
Yes, ma'am.
Ajit Raut district along with 15, 20 words of the supporters came to the sport. You people were heavily armed also.
Because
I assaulted a family member with the intent to kill them. Family member.
ମାମୁଁ ଘରକୁ ବୁଲିବାକୁ ଯାଇଥିଲୁ ଆମ ଭିଲେଜ ଟା ହଉଛି କୋଳିଦାସପୁର ହିଞ୍ଜିଳି ଅଣ୍ଡରରେ ଆମେ ଯାଇଥିଲୁ ମାମୁଁ ଘରକୁ ବୁଲିବାକୁ ସୋ
What was the occasion where
occasion ମୁଁ ଯାଇଥିଲି ମାମୁଁ ଘର ହଉଛି ବୁଲିବାକୁ ଯାଇଥିଲି ସେମିତି କିଛି ମୋର intention not to because I am
what is the criminal antecedent of this?
I have no criminal antecedent. So far antecedent is concerned, I have no.
What are you doing?
A student might have given diploma and next the page 51 diploma mechanical student page 51.
Where is that anticipatory bill is rejected? Order. You're not. Where is, have you filed it?
I have not filed, but order.
Give me.
Yes, ma'am.
देखो if the petitioner has invoked the jurisdiction of this court under 482 CRPC, seeking quashment of the entire criminal proceeding arising out of GR case number 737 of 2022, pending in the court of JMFC, Purushottam. It was at the outset the 11 State Council pointed out that the petitioner had approached this court by filing ABPL number 5319 of 2023 seeking anticipatory bail. However, the coordinate bench of this court by the order dated 22/6/2023 has been pleased to dismiss the prayer for pre-arrest bail. Facing the next further. Confronted with that situation, the petitioner has now filed this petition. Also, it appears to be a. I will not write that then. What have you written? Petition. Also, next paragraph. The petitioner, the counsel for the petitioner submits that the petitioner is a 19-year-old boy who is a diploma student. He is a diploma student. The allegation against him is that he, along with 15-20 other people, he, along with 15-20 villages, villages, appears to have attacked the complainant and their family member, causing them simply injury. Therefore, the FIR came to be registered against him under section section page 6. In the meantime, all the co-accused persons.
Yes, my lord.
In the meantime, all the co-accused persons have already been granted bail. However, the petitioner could not avail the concession because he has been absconding. Next one. The charge sheet filed by the investigating agency indicates that the petitioner has been absconding. The counsel for the petitioner submits that he being his client being a student is scared of appearing before the police. That's the reason he has absconded, but he has no intention to avoid either the investigation or to face the trial. Next paragraph. Having considered the aforementioned facts and circumstances, it would be circumstances. He further submits that taking into consideration the above facts and circumstances, he may be enlarged on bail. However, I'm afraid that while exercising jurisdiction under 482 CRPC, granting anticipatory bail, enlarging the petition on bail may not be within the four corners of law, particularly when the anticipatory bail application has already been rejected. Having said that, the petitioner has been having said that, the liberty is granted to the petitioner to surrender before the appropriate court and seek remedy available under law. Within 10 days. Within 10 days. within 10 days. The trial court is expected to decide the application expeditiously, decide the bail application expeditiously on its own merit. That is the best thing I can do.
Courts were, because 307 is the trial by court of session. So bail application will be before the higher court. If in case reject, that will be.
No, that I will not settle the course of how we move application, what everything I'll do. Then you will tomorrow 482 petition will be filed and saying that please draft a petition and give me.
No, sure, that's why my lord, otherwise my lord.
Oh, this is very innocuous. You see, within a four corner of law, I can do whatever.
And that
you want to go to sessions court?
Yes, my lord.
I will write that instead of trial court. I'll say that appropriate court. Appropriate court means you have to, you go to sessions court and surrender.
Because
you will be getting bail in the same day. What is the big deal about?
Because the records are in the magistrate court, so how will it will be transferred to the session court? That's why
These are, I can't.
So
this is
because the records are available in the magistrate court, unless the record will be transmitted.
That also I'll have.
Usually order.
Then I'll depute some officer from here. He'll go.
No, madam, that is the cost of the petitioners.
These things in 482, how do you expect all these things to be done? Micromanagement of the court proceeding of the trial court will be done by 482 petitions?
The moment the prayer for bail is rejected before the
I should have straight away rejected your petition. But having taken into consideration the young boy, so I'm giving this much. This much is enough for you to get a bail.
File it there in the sessions.
This is enough. If you show this order, no sessions court will stop you getting bail. Everything I have written. What anything else you want to say? That also I'll record.
And taking into consideration the co-accused clarity will be maintained. So co-accused person will.
I have already said all the
co-accused disposed of on the same day. Only disposed of on the same.
No, that I will not. That I will not do. Then I have entertained 439. Yes, that I will not.
Only
Please. I'm interested to help, but not to that extent because I have to be within that four corner of law.
Only that was.
I'll see what best could be done. This much I have said, but I'll just correcting. I'll just see.
Same day.
Next.
24.
No, but they are in the first hour.
438 you tried, you didn't get, so 482 you filed. For quashing, you have not spoken a single sentence. It is a quashing petition?
Yes, ma'am.
On merit, you have not said a single sentence. Why it should be called quash?
And as far as merit is concerned, omnibus allegation. Allegation are omnibus in nature.
You tell me 482 is maintainable for a accused who has absconded? A absconding accused seeking quashment of a charge sheet is possible
because
in any Indian court. You have absconded, charge sheet is filed. 82, 83 proceedings should have been initiated against you by now. You are filing quashing and you are asking so many relief. So it is not possible at all. It could be easily dismissed, saying that he is absconding, so no 482 is maintainable. Simple, one line. But this much intelligence I am giving because he is a young man. Take it. Take it. Yes.
Nobody there, my
35.
Again. Next. Sorry. Done. करना है